abanye abantu ebapho kuhla akekho umuntu ozalela ukuthi angazuzi ngengane yakhe nathi sibheke okuthile ngomzakhulelwa njengoba ngangithi umzakhulelwa ngangilandela ukuzaleka kwami mina uqobo ngagcina ngithi-ke namhlanje ngizele umzakhulelwa uye yedwa indodana yami ekhona la ekhaya engethembele kuyo iney'ngane la igcekeni iganiwe ithemba lami benginalo kutefa ukuthi ngelinye ilanga ingane yami izophuma kuleya ndawo ekuyona ngendlela ebengimbona ekhuluma ngayo nangendlela ebengazi ngayo nami ngoba bengazi ukuthi umzakhulelwa wasiya umbulali kaMeyiwa.
Not far from the Sibiya home is the Ntanzi homestead, the family of the youngest of all the accused. 30-year-old Mogane Ntanzi is also referred to as accused number 2. They tell us he has been the breadwinner of their family, providing for 10 people, including his 9-year-old child. Because Mogane was the sole breadwinner, his absence also meant there was no money to even travel to Gauteng, where he is currently incarcerated. They say he got himself a lawyer, as none of them could afford those legal services. All they could do is watch the trial on television, especially on behalf of their mother, who can't bring herself to watch the proceedings. Every time he enters the dock, she leaves the house to get an update later. It was a shock to them when Advocate Mngomezulu dropped the news of his withdrawal.
Esathatha naye izinto ngendlela yakhe afuna athathe ngayo ukuze egcine bamele kanti bese sithi mhlawumbe sithembile emephethelweni for ukuthi ngwanakho usebatholakele ngendlela engibuka ngayo lo mmeli ubesebenzile ngoba kuzovele konke lokhu nje nokuthi abasolo yilaba abenzi baletho yilaba kusithemba yena ngendlela besimbone ekhuluma ngakhona nandlela aphenye ngayo kuze sigcine sekubuvela ngale ndlela siyambonga yena ummeli lapha khona ngoba konke lokhu nje athi lokhu sikhuthanisa ngene.
In an unexpected but not surprising turn, Defo wrote to the state informing it that he had resolved issues with what he terms relevant stakeholders and will therefore continue representing accused number 1 to 4. But there's a catch. He has listed a number of demands that he wants adhered to before he and his clients can show up in court on Tuesday. Those include a separation of trial between his clients and accused number 5. He also wants a new judge appointed in the matter and the prosecutor, Advocate Maloyi, removed from the case. Defo says he also wants Police Minister Begicele to be removed from his position and be investigated. In the same statement, he reveals a fresh, new reason why he withdrew from the matter. Without substantiating, Defo accused Judge Maumela of witchcraft, citing it as the main reason why he decided to leave the case. Although at the time of this interview these families did not reveal this information, they agreed that he was subjected to unfair treatment in court. Muzikau Khalelwa and Bongani are said to have made confessions, but according to Advocate Mngomezulu, these were obtained under duress. He claimed his clients were severely assaulted through the use of what he called apartheid tactics to get them to confess. He called on the court to hear a special plea for a trial within a trial. His plea fell flat after Judge Maumela ruled that he failed to follow proper court procedure. Defo had also not filed papers as required for a court application, but addressed the court from the bar instead. To top it all, the state had not submitted these alleged confessions to the court or indicated that they would depend on them. The families believe that their children are innocent.
Umfana lo waboshwa konje kwakumhla kabani mama? Mhla ka 30 June. Mhla 30 June. Mhla ka 30 May yes. Waboshwa mhla ka 30 May inyanga yonke singamazi ukuthi ukuphi. kwazothi ngo June angisazi ukuthi kwakumhla abantu bafika naye la ekhaya ma befika naye la uyangitshela ke ngoba bathi angiye kuye ngiyokhuluma naye uthi baba ngiboshiwe ngendlela ebengishaywa ngayo bengibulawa futhi bengitshela bethi bazongibulala njengomnyu khona abambulala eForce Rollers amaphoyisa amdubula bathiwa yiba bambulala nami ke bazongibulala bemvalele ehlathini laba bemvalele khona ngendlela ngagcina ngivuma bethi angivumi ukuthi ngabulala Meyiwa kodwa okokuqala babetha kacindezele laba bazomnikeza 100,000 wathi ngalile baba ngoba ngiyazi into engingayivumela engathi ngizothi laba ngibacindezela ngani ngazini ngangikuphi wathi ke bathi bazongifaka icaleni sebengifakile ke ngigcine ngivuma istatement abangibhalise sona ngizivumile angivumi ngoba ngikwenzile ngivume ngoba ngizikela impilo.
Ntanzi's family also claimed that the same happened to their son.
Wathenjiswa 3 million babemshaya before uthe vumele icala umbhaxa nje umfaka nasefrijini sazi efriji bafaka ngoba bemfaka belivulile noma babecimile ngazi ke la kodwa ke khona awuthole lokuthi wafaka efrijini
afake efrijini yabo phejele
amanje kusanoma bayesejele noma kodwa khona babembombile bona noma bengamfakile esitokisini kodwa babembambile apho babembambe khona.
Sibiya's father says he raised the issue at a magistrate's court where he had been appearing for a different matter and was subsequently moved to a different prison. While the state had not submitted these confessions as evidence or indicated that it would rely on them, it has remained tight-lipped on its strategy to nab the accused. The confessions form part of Defoe's representations to the NDPP in a bid to have the matter withdrawn. For some members of the Meyiwa family, these developments were expected. They believe the 5 men standing trial are innocent. They say a plan is on the cards for this docket if the National Prosecuting Authority decides not to prosecute.
Private prosecution.
Oh, so that's your next step, private prosecution.
Private prosecution.
Meyiwa says his brother's case has been at most marred by corruption.
Leading investigator kwa case 375, 635, 636 yantshontsha statement esasodala ukuthi kuboshwe umuntu wayelapha endlini yasitshontsha leso statement ingakho kwavulwa lo case 375 labantu babawu5 baboshela ukuthi kuzanywa ukuthi babefuna yona ukuthi le case ivalwe kuthiwa ifaka sihlamba bukho noma vele sebethenge nama witnesses kuboshela abafana aba5 ivale ingabe savela leli bashaya phansi ke manje nali seliveli.
On the 26th of October in 2020, Police Minister Begicele visited the Meyiwa family to update them following the announcement that 5 suspects had been arrested.
Chico, I want you to hear what Siyabonga Mia had to say to us yesterday for your benefit and for the benefit of any of the listeners who are hearing us now who may not have heard the conversation yesterday.
They know that the person who shot Senzo is Longwe Twala.
Why would they protect him?
Senzo died trying to protect his girlfriend. I went to the DPP's Chauge's office and he said to me the people who were inside the house were lying. You understand? But why they didn't sign those warrants, I don't know.
Why would they protect him, do you think, Siyabonga? Why would they protect the people you are saying are guilty for killing Senzo Meyiwa?
Some people born with a silver spoon in their mouth. It's so unfortunate for Senzo who he didn't born with a silver spoon in his mouth. Everything that he had, he fought for it.
What's your response to those allegations? Siyabonga Mia basically making the point that your son is the son of a very powerful man, words Longwe himself has used to describe you. What do you make of that, of those accusations?
I think it's important for someone to understand that I'm not powerful. And to be honest with you, why would Senzo's childhood friends Tumelo Madalem Togozi to defend my son? Common sense.
My Lord, with the leave of the court, may I hand in this copies to the witness so that I can ask the witness to read it for us.
Okay. Well, we just want to put on record that the interpreter is now Mr. Lebelo. Okay, thank you.
Morning, Mr. Mogane.
Good morning.
You see the documents I have given to you.
Yeah, you gonna talk about John? Yes, I see them.
Yes, what is written outside?
Statement regarding interview with the suspect.
What is statement regarding interview with suspect?
Okay. Let's go to paragraph 1.
Paragraph ya mathomo.
You can place it on the record. What is the SAP number for that form?
SAP number ya yona mo form ni go ireng.
What's in SAP number at the form?
SAP 3M in brackets small m.
SAP 3M in brackets small m.
My Lord, it's SAP 3M in brackets small letter m. Yes, continue read after the emblem. South African Police Service, read it.
South African Police Service instruction statement regarding interview with suspect.
Ilapho kufunda khona ukuthi kwakuqhubekani isikhathi kukhulunyana nomsoko.
Yes. Can you read paragraph 1? Completion on statement.
Paragraph ya mathomo.
Completion of statement. The station commander must consult with the prosecutor on circumstances in which the prosecutor requires that the only statement of a suspect be obtained.
Uprosecutor kufanele akhulume. Uprosecutor ke ufanele akhulume.
It's the other way around. The station commander must consult.
Station commander kufanele akhulume no prosecutor. Ezindaweni lapho ke uprosecutor edinga ukuthi kukhishwe warning statement kamsolwa.
Can you just read the whole paragraph so that yes, thank you.
In every such case, the suspect must be interviewed and this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect is arrested or not.
So zonke isikhathi umsolwa uma kufanele ukhulume naye kufanele lesi statement sigcwaliswe. Le statement ke kufanele ukuthi sifanele sigcwaliswe ngazo zonke izikhathi lapho ke umsolwa ukukhulunywa naye. Ungabhekiwe ukuthi umsolwa useboshiwe noma akakaboshwa.
Paragraph B.
Paragraph ya boraro.
Paragraph B.
B.
Yes.
The member who conducts the interview with the suspect is to complete the statement fully in the presence of the suspect.
Kuthiwa ke ozobe khuluma ke nomsolwa kufanele agcwalise ngokuphelele i-statement lesi phambi kukamsolwa.
Okay. Paragraph C.
Paragraph C.
If there's not enough space on any of the pages, the member must continue on a separate follow page. This follow must be signed by a member, suspect, interpreter, and the commission of oath, and must be attached to the statement.
Then again, uma ingekho indawo eyanele ekhasini iphosa lifanele liqhubeke libhale kwelinye ikhasi. Leli khasi lifanele libisayindwe futhi ilona liphoyisa umsolwa utoliki futhi ke kube ne-commissioner of oaths and kuke lifanele linamathiselwe ku-statement.
Paragraph D.
Paragraph D.
The commissioner of oath must sign on every page of the statement.
Kuthiwa ke ucommissioner of oaths kufanele asayine wonke amakhasi statement.
Yes, paragraph.
The commissioner of oath must sign on every page of the statement. If the suspect is a child below the age of 18, the parent, guardian, and appropriate adult must sign every page of the statement.
Uma kuwukuthi ke umsolwa useyingane engaphansi kweminyaka eyishumi umzali noma omgcinayo noma ke umuntu omdala okhona ufanele asayine wonke amakhasi estatement.
That's a good piece, my lord. Sorry to interrupt my learned friend. The state objects against this line of cross-examination by my learned friend. Firstly, we don't see what the relevance of this cross-examination is. Secondly, the witness said yesterday that the interview on the 17th was not a warning statement. And if one looks at what the exercise that my learned friend is busy with, this regards a warning statement, unless if my learned friend intends on canvassing a warning statement of accused accused number 2 with the witness. But if one looks at paragraph 1, it states clearly there that this form is applicable in the case of a warning statement, and that in that case, the station commander must consult with the prosecutor. So whatever follows, my lord, is subject to the obtaining of a warning statement and not an interview that the witness has testified about.
Yes, ma'am.
Thank you, my lord. My lord, I think I've clarified this yesterday, my lord.
Not clarify it again because Mr. Baloy is now objecting.
Yeah.
You remember my comments yesterday?
Yes, ma'am.
Yes.
My lord, I am not referring the witness to this paragraph because I'm saying that this document was signed or completed by any of the accused.
Fine. What is that document?
It is a warning statement, my lord. And
okay, fine. Accordingly,
it's the instructions that are given, yes.
When one wants to take a warning statement,
for the police officer to record when he's interviewing the suspect.
Is it for an interview or for the taking of a warning statement?
It is for an interview, my lord. That's why I read paragraph 2, because it says the member, paragraph B, my lord.
Let's start from the beginning. What is that document for? Because Mr. Baloy says it precedes the taking of a warning statement, and you are saying it's for an interview.
My lord, if I can just repeat myself, my lord, yesterday the witness testified that they were interviewing the suspect in the courtroom.
Yes, yes.
Then my question was, my lord, was it recorded? Then I said, where was it recorded? Then I went back to this form to say, this form says the member who conducts the interview with the suspect has to complete this statement fully in the presence of the suspect. Okay. And paragraph A, my lord, says, irrespective of whether the suspect has been arrested or not. In other words, my lord, whenever there is an interview between the police and the suspect, that interview has to be recorded because there are allegations, there are constitutional rights that are explained by the police officers at that time.
Fine. And this form, what is it for? The very form. Is it for an interview?
It's for the statement regarding interview with suspects. It's written clearly on the instructions, my lord. In statement regarding interview with the suspects.
Yes, Mr. Baloyi.
As a court, please, my lord, this is where, with the greatest of respect, we submit that my learned friend misses the point.
Why don't you bring, okay, you know what, just bring me the law.
Yes.
Okay, because you are at different poles.
Yes,
Can you give me the authority you're relying on?
Yes.
And please, Mr. Shololo, give me the authority you're relying on.
Yes.
And you adjourn for that.
Yes, but can we just make this one point before we adjourn, my lord? Just this one point. If one looks at paragraph A, it says clearly the station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement.
So the prosecutor must also be involved.
Yes, and this is the emphasis must fall on warning statement. The station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement of a suspect be obtained. And secondly, it says in every such case, in other words, in every such case where a warning statement is required. It doesn't refer to any interview with the suspect. And my learned friend is now opines that in every instance, when a police officer conducts an interview with the suspects, then this process must be followed. It's only in the case of a warning statement.
And that is, that, as I understand the law, that precedes the charging of the suspect. Okay, can you get me the law so that we don't argue in a vacuum? How long do you want me to adjourn?
My lord, maybe 30 minutes because I've already have the authorities. I'll just make the copies.
Do you have any authorities for yourself?
We still have to look up, but it shouldn't take that long.
Okay, 45 minutes.
Chico, I want you to hear what Siyabonga Mia had to say to us yesterday for your benefit and for the benefit of any of the listeners who are hearing us now who may not have heard the conversation yesterday.
They know with the person who shot Senzo is Longwe Twala.
Why would they protect him?
Senzo died trying to protect his girlfriend. I went to the DPP's Chauge's office, and he said to me the people who were inside the house were lying. You understand? But why they didn't sign those warrants, I don't know.
Why would they protect him, do you think, Siyabonga? Why would they protect the people you are saying are guilty for killing Senzo Meyiwa?
Some people born with a silver spoon in their mouth. It's so unfortunate for Senzo who he didn't born with a silver spoon in his mouth. Everything that he had, he fought for it.
What's your response to those allegations? Siyabonga Mia basically making the point that your son is the son of a very powerful man, words Longwe himself has used to describe you. What do you make of that, of those accusations?
I think it's important for someone to understand that I'm not powerful. And to be honest with you, why would Senzo's childhood friends to to defend my son? I mean, common sense.
Hi guys, I think now we can actually see that Baloyi is trying to just dodge some things here, because obviously when you're when the police is doing their duties, every statement actually or interview that is taken by the police must be recorded. Everything must be recorded. So why is he dodging the bullet? Why is he running away from this? Whether it's a statement, whether it's a confession, whatever it can be, but it has to be documented. That's the thing. That's what they were actually, that's why Mshololo is actually like trying to find out why were you not actually following certain procedures, because she wants to pull out the procedural things that were not adhered to. So Baloyi is just playing hide and seek. He's just running up and down. Maketile, how are you? How are you? How are you? I was actually telling Nonhlanhla that Maketile is actually at work. And Jiggy, here you are. Henry are saying Baloyi and his cover-ups, Mari. You see, that's the thing. It's like he wants to just rubbish what Shololo is supposed to come in and put on the table. So you can actually see that there's a lot of fights here when it comes to the legalities, because when you look at it, the legalities were not actually followed the right way. I mean, that's the legalities were not followed the right way. So that's where most of these things are giving us some problems. I have a voice note that was sent by Ntanzi earlier on. I just want you to listen to this voice note quickly, guys. I just want you to listen to this voice note. I want to check also on the other court. There is a case of Jub is actually in court today. I just want to see in the interim if we can just check what is happening there as well. But let's just hear this voice note quickly that Ntanzi sent me early in the morning. early in the morning. Market lesson, yo guys, it was hectic at work for the past 2 weeks. Yeah. Even myself last week, I couldn't come on live. It was a bit hectic. There was a lot of things that needed to be done. So I was actually busy. Katlamini are saying, morning guys, court not yet started. No, court has started, but now we are just waiting for the short adjournment. They want to check on some bison laws and some bison versus state what laws of what of 1949. Let's just see what they will come up with now. So let me just play this. Let me just play for you this voice note. I want you to hear this. I want you to hear this interview.
Ntanzi, hello. Hello, how are you, sir?
I'm okay. Bunja Mr. Anonymous. No, Emil.
Kuhle kakhulu. Njengenjwayelo masekushayela izikhathi uyakhathale.
Oh, okay. Hawu madoda. Hayi Mr. Anonymous, lento ibuhlungu. Yazi manje yazi kanjani? Lento umuntu lo oyikhulumayo ngisebenza naye. Wangena straight ukuthi kwenzakalani. Yabo lento eyakhulunywa ekhulunywe court ukuthi washawa lo mfana uSibiya waziwa imoshela. Ikhulunywa nje court mina sengiyayazi.
Hawu madoda.
Lokuthi uyena bobabili bayamshaya lo mfana uNtanzi benogininda yabo. Lo munye bamnika iMPD yamchaphaza lo mfana waziwa imoshela yabo. So manje umuntu mesekhuluma manga kanje uyathi vele ngibona intombi siyamba ukuthi ubulungiswa abukho. Lo muntu lezinto aleke ikhuluma lapho nje ecourt isiyangicika lento iyangikhipha nje yabona nje ngicika ngoba manje ukuthi iyacasula lento ngoba ukuthi kwaqhashathwa nabafana ngoba kubonakala ukuthi abazinithu ngamalungelo abo yabo leyo kahle nendlela nje ababoshwa ngayo ayikho sharp. Ngoba ngithi ngomunye umshini esiwusebenzisayo la i-MCD into ofika ubeke kuyona isithuba maybe kuthiwa bayakususpect bayakufuna bayakususpect lento izosho ukuthi wena unama-cases kanjani ama-outstanding and mhlawumbe ikhona i-warrant of arrest ofunelwa yona yabo. Kodwa manje ayenzekalana yonke leyo nto kwavele kwathatha labafana bayosha bavumisa amacala abangawazi. And yena lolo okhulumayo uyongena straight kinaye emsebenzini. Nalento ukuthi athi uyobhala istatement ngomhla 25 yagabuka ngahleka nje. Engitshela ebuseni ethi ngiyobhala istatement. Ngabuka ngathi mina kwabosha abantu ukuthi phela akunadocument akunastatement. Wasenza we-arrested ayiyenza same time arrestatement muyiphoyisa uqeda ukubopha umuntu. Kodwa yena ungitshele nje mhlawumbe 5 October lasiye sonke emsebenzini wathi hayi usayobhala istatement umuzo yecourt this week uyabona. Ayazi nje hayi iphetha kanjani lento Mr. Anonymous iyangidina ngoba uyabona ubuzobona ukuthi amaphoyisa asebenza udoti enza udoti nje amaphoyisa. Nami ngilona iphoyisa Mr. Anonymous labathi ngisebenza labo ngiyababona yabona intombazana ukuthi umohola lo. into engakwazi ngisho ukubhala i-occurrence book kufanele ahambe mhlawumbe enze i-departure mhlawumbe uye usebenza eThekwini kufanele ngimbhalele mina ngithi yena uya-departure uyangitshela ukuthi manje ngiyosenza ngimbhalele ngoba yena akakwazi ukuthi angabehla leyo nto phansi ayibhale phansi yabo leyo nto kanje Anonymous ukuthi le nto idicilela ini isifeza phansi akekho umuntu ongathembana nephoyisa amaphoyisa mezokwenza nje yabo manje asekhuluma istory aformulate istory le story siyabheda Mr Anonymous sibahlulile
mfowethu
ngoba manje konke labantu babalinka ngeinhlamvu zesibhamu yabo umthwalo yabo lento ekhulunywa manje kuthiwa idocket akho amadocket lawo kusho bona babe please ugininda bedlala ukuxhashazwa ugininda lo yabo ngoba yabo maboy yabona nje akhe yabo ukuthi nje bande bafostele i-arrest engekho bayifostelela bona yabo ayiyabheda le ndlela okusetshenzwa ngayo la yabona le unit mina bengathi mina kuyi-tracing e-check amalento ama-dockets lawa avaliwe kwi-tracing unit lena le kagininde yobugebengu ukuxhashazwa abantu kwenziwani ibheda too much lento Mr Anonymous
iyabheda futhi
mfuthu yazi nje angeke ngiyivale lapho ngoba manje yabona abantu babona day by day lapha emsebenzini yabona nje ubona ukuthi buke labo ubona naba labo nothi laba abasembarasa lapha ekhona
manje
hayi okay wangithaya ngiyabonga
mfuthu
okay
right.
It was a blow, as these families say they had not had contact with Advocate Malisela Defu, who had been representing the pair and 4 others.
Kulungile. uNkulunkulu usabele asiphokumbi nathi abanye abantu ebaphokuhla. Akekho umuntu ozalela ukuthi angazuzi ngengane yakhe. Nathi sibheke okuthile ngomzakhulelwa njengoba ngangithi umzakhulelwa ngangilandela ukuzaleka kwami mina uqobo ngagcina ngithi ke namhlanje ngizele umzakhulelwa uye yedwa indodana yami ekhona la ekhaya engethembele kuyo ineyingane la igcekeni iganiwe ithemba lami benginalo kutefa ukuthi ngelinye ilanga ingane yami izophuma kule ndawo ekuyona ngendlela ebengimbona ekhuluma ngayo nangendlela ebengazi ngayo nami ngoba bengazi ukuthi umzakhulelwa wasiya umbulali kaMeyiwa.
Not far from the Sibiya home is the Ntanzi homestead, the family of the youngest of all the accused. 30-year-old Mogane Ntanzi is also referred to as accused number 2. They tell us he has been the breadwinner of their family, providing for 10 people, including his 9-year-old child. Because Mogane was the sole breadwinner, his absence also meant there was no money to even travel to Gauteng, where he is currently incarcerated. They say he got himself a lawyer, as none of them could afford those legal services. All they could do is watch the trial on television, especially on behalf of their mother, who can't bring herself to watch the proceedings. Every time he enters the dock, she leaves the house to get an update later. It was a shock to them when Advocate Malisela Defu dropped the news of his withdrawal.
esathatha naye izinto ngendlela yakhe afuna athathe ngayo ukuze egcine bamele kanti bese sithi mhlawumbe sithembile emephethelweni for ukuthi ngwanakho usebatholakele ngendlela engibuka ngayo lo mmeli ubesebenzile ngoba kuzovele konke lokhu nje nokuthi abasolwa yilaba abenzi baletho yilaba kusithemba yena ngendlela besimbone ekhuluma ngakhona nandlela aphenye ngayo kuze gcine sekubuvela ngale ndlela siyambonga yena umeli lapha khona ngoba konke lokhu nje athi lokhu sikhuthene sangene.
In an unexpected but not surprising turn, Defu wrote to the state informing it that he had resolved issues with what he terms relevant stakeholders and will therefore continue representing accused number 1 to 4. But there's a catch. He has listed a number of demands that he wants adhered to before he and his clients can show up in court on Tuesday. Those include a separation of trial between his clients and accused number 5. He also wants a new judge appointed in the matter and the prosecutor, Advocate Baloyi, removed from the case. Defo says he also wants Police Minister Begicele to be removed from his position and be investigated. In the same statement, he reveals a fresh, new reason why he withdrew from the matter. Without substantiating, Defo accused Judge Maumela of witchcraft, citing it as the main reason why he decided to leave the case. Although at the time of this interview these families did not reveal this information, they agreed that he was subjected to unfair treatment in court. Muzikau Khalelwa and Mogane are said to have made confessions, but according to Advocate Manisela Defo, these were obtained under duress. He claimed his clients were severely assaulted through the use of what he called apartheid tactics to get them to confess. He called on the court to hear a special plea for a trial within a trial. His plea fell flat after Judge Maumela ruled that he failed to follow proper court procedure. Defo had also not filed papers as required for a court application, but addressed the court from the bar instead. To top it all, the state had not submitted these alleged confessions to the court or indicated that they would depend on them. The families believe that their children are innocent.
Umfana lo waboshwa konje kwakumhla kabani mama? Mhla ka 30 June. Mhla 30 June. Mhla ka 30 May yes. Waboshwa mhla ka 30 May inyanga yonke singamazi ukuthi ukuphi. Kwazothi ngo June. Angisazi ukuthi kwakumhla kabani bafika naye la ekhaya. Ma befika naye la uyangitshela ke ngoba bathi angiye kuye ngiyokhuluma naye. Uthi baba ngiboshiwe. Ngendlela ebengishaywa ngayo bengibulawa futhi bengitshela bethi bazongibulala njengomnyu khona abambulala eFosrolas amaphoyisa amdubula. Bathiwa yiba bambulala. Nami ke bazongibulala. Bemvalele ehlathini laba bemvalele khona. Ngendlela ngagcina ngivuma bethi angivumi ukuthi ngabulala Meyiwa. Kodwa okokuqala babetha kacindezele laba. Bazomnikeza 100,000. Wathi ngalile baba ngoba ngiyazi into engingayivumela engathi ngizothi laba ngibacindezela ngani ngazini ngangikuphi. Wathi ke bathi bazongifaka icaleni sebengifakile ke ngigcine ngivuma istatement abangibhalise sona ngizivumile angivumi ngoba ngikwenzile ngivuma ngoba ngizikela impilo.
Ntanzi's family also claimed that the same happened to their son.
Wathenjiswa 3 million. Babemshaya. Before uthe vumele icala. Umbhaxa nje umfaka nasefrijini. Sazi efriji bafaka ngoba bemfaka belivulile noma babecimile ngazi ke la kude ke khona. Awuthole lo ukuthi wafaka efrijini.
Afake efrijini yako pheja.
Ngamanje kusanolwa esejele noma kude khona babembombile bona noma bengamfakile esitokisini kodwa babembambile apho babembambe khona.
Sibiya's father says he raised the issue at a magistrate's court where he had been appearing for a different matter and was subsequently moved to a different prison. While the state had not submitted these confessions as evidence or indicated that it would rely on them, it has remained tight-lipped on its strategy to nab the accused. The confessions form part of Defo's representations to the NDPP in a bid to have the matter withdrawn. For some members of the Meyiwa family, these developments were expected. They believe the 5 men standing trial are innocent. They say a plan is on the cards for this docket if the National Prosecuting Authority decides not to prosecute.
Private prosecution.
Oh, so that's your next step,
Private prosecution.
Meyiwa says his brother's case has been at most marred by corruption.
Leading investigator kwa case 375, 635, 636 yantshontsha statement esasodala ukuthi kuboshwe umuntu wayelapha endlini yasitshontsha leso statement ingakho kwavulwa lo case 375 labantu babawu5 baboshela ukuthi kuzanywa ukuthi babefuna yona ukuthi le case ivalwe kuthiwa ifakazi hlamba abukho noma vele sebethenge nama witnesses boshela abafana abo5 ivale ingabe savela leli bashaya phansi ke manje nali selivelile.
On the 26th of October in 2020, Police Minister Begicele visited the Meyiwa family to update them following the announcement that 5 suspects had been arrested.
Mfethu wadidisa umanje wadidisa wamtshela ngokheli ukuthi ukheli yena wabutshela nje ngokheli ukuthi yena uzoboshwa nalabantu abawu5 ibona okuyibona suspects umuntu okhuluma ngalabo abantu abawu5 vele ngibona nje ukhuluma into engekho wayizodlala nje ngoledi ezokhuluma into engekho ngoba into engixakayo sasikhuluma naye uyazi ngoba yabo lama investigators at 375 bekade reporter kuyena uminister ucele obuthelezi benomakhuba be reporter ku minister ucele bese ukuthi laba abanye be reporter ku Khehla Sithole in first laba kwakufanele nabo laba ngababa reporter ku Khehla Sithole ngezathu zokuthi khona ubugebengu obenzakalayo kwacaca ukuthi no aba reporter ku minister ngoba lapha into ekhulunywa lapha akuyona le fanele iveze iqiniso cover up yodwa ehlanganiswe lapha base ba reporter ku minister uminister besike sikhuluma ngisho naye efonini esho ukuthi no uyazi naye ukuthi lento enziwa yilabo abangala ayikho nabo abantu abakhuluma into eyona.
So nimbuzile manibona ukhela ngavele ecourt ukuthi ukheli kwenzakaleni?
No akaze simbuza ngavele ngabona ngayibonela nje the day ekhuluma indaba yokuthi in first ngabona before akhulume leyo nto khona izinto engase ngiyibona angifuna ukusho ukuthi yini kodwa khona izinto ayikhuluma ngabothi I know sekhona into influence wrong bese ngibona vele ukuthi use cishe mhlawumbe khona into abamsabise ngayo noma khona amacala bawaziwe laba bantu abangala laba bakhe 63 ngoba bagudike lapha ekubophisena abantu nokuthi nje mhlawumbe khona amacala bawaziwe bamsabise bazowaveza.
The South African Police Service says it cannot comment on matters that are still in court.
As you are well aware, the case is currently in court and sub judice. Any issues pertaining to the case must be directed to the NPA and the court itself. Evidence will be dealt with in that forum, and as such, the SAPS cannot comment on cases that are in court.
The side of the Meyiwa family that believes that these are the suspects says it has no intentions to comment on the information by Sfiso. It says the onus is on the state to prove that the confessions and or admissions made by the accused were made freely and voluntarily without undue influence.
It's said we have spoken to General Khehla Sithole, what is the head of the investigation, who General Ntanzi will update us if anything happens or if there is any breakthrough in the case. So, and today we wake up to the news that the firearm has been found. And we're just hearing it from the media. In the of the media, we already knew it maybe a month ago or 2 months ago. There was someone who was claiming she was a Senzo. We don't know. Only the police, Lawa Asabenzifana, no general told or Azil. Because you must remember there are 2 teams in this investigation. There's a team that there are 2 teams of who are supposed to be working together, but they are not working together. So the team, obviously, like Khehla, they know which is someone who has been claiming which he was there. But we were told that when there's a time for arrest, there will be people who are claiming which they were there. Yes, we all know which there was no one who entered the room. Amaphoyisa njengamanje kumele engabe abopha uLongwethwala for killing uSenzo. Senzo was shot by Ulongwethwala. There was no one who entered the house. bese ebopha all these police who have defeated the ends of justice. Senzo was shot by Ulongwe Twala. A call was made by Tumelo. The first call when Senzo was shot was Tumelo, a boyfriend Kazandi, of which he didn't know by name, had shot Senzo, and then a phone was dropped. At the background, Ukeli, she was crying, and that information was given to the SAPS. Why they do not want to arrest Ulongwe Twala, I do not know. For me and my family, it is up to them. It's long overdue. We've said to the police several times, and the good police who are in the side of justice have said it. There was no one who entered the house. Yes, who are working on this case. Even who advocate Chauke in Gauteng, he confirmed it. According to the information that was given to him, there is no one. I had a live recording of Advocate Chauke saying, according to him as an advocate, experienced advocate, there was no one who entered the house.
Important to start off with reflecting exactly that. The family has always had a cry to say that police and investigating authorities never say anything to them. Over the last 6 or 7 years since Senzo was killed, information has been coming to them through the media. And in fact, I remember quite distinctly Meyiwa, Senzo's mother, saying that another issue that they told Begicela about when he went to go visit the family last year is the fact that there were always different police investigators coming to give them information, which they believed was also causing a significant delay in the matter being actually finalized. Now, subsequent to Cele's visit, he was there sometime last year, late last year, around this time actually. In July, Cele had established a special unit that would be looking into this particular matter of Senzo Meyiwa's killing. And of course, you'll remember that Cele came under a lot of fire because he gave deadlines that he never met. He initially said that by Christmas, that was Christmas in 2018, there would be feedback, and that didn't happen. Then he promised by Easter last year in 2019 that there'd be feedback. There was still no feedback. And in actual fact, when Cele had gone last year, it was because Sam Meyiwa, Senzo's father, had also passed away. So he was there to pay his condolences to the Meyiwa family. Now, that's one of the issues. But just like Siyabonga Mia was saying today, Senzo's mother also told us that they know exactly who killed Senzo Meyiwa, and in fact, she was of the belief that the same people who killed Senzo were also responsible for her husband's death. Let's take a listen into what she had said at the time.
Noma ngoba ungaqhamuka azosiza ngani ukube bathi bebulala uSenzo bazoza la ekhaya bathi simbulala uSenzo ubulayo ngephutha bazoza la ekhaya bathi sizoxolisa la ekhaya kubafika eqaleni ngasathi bebulala uSenzo akaze kufike umuntu la ekhaya ezobika ukuthi uSenzo ubulayo ubani abaze bafike kuba bafika isikhathi lokuqala bathi uSenzo ufike ngephutha bese besidadake bakhokhela amaphoyisa abasikhokheli thina babhizi bakhokhela amaphoyisa. Iqiniso lilapho nje bakhokhela amaphoyisa wasikhokheli thina babulala uSenzo kuyaziwa khona mangasalala ebusuku abangalala ebusuku hayi kahleni makithi kahleni abafike namhlanje mangibulala bebe ngibulala babulala ingane kaSenzo sife bese beyidleleke imali.
Well, Tami, as you can see, they are very emotional in Ntomfuthi Meyiwa, and one of the biggest cries actually was the fact that the family is not being taken care of. And the fact that she's raising one of Senzo's daughters, who is a teenager in high school, and her biggest cry was that Senzo's killers are out there. She says that these people have money. Now we heard from Siyabonga, he's named Longwe Twala. I mean, that's something that's a name that's been on the rumor mill for the longest time. But the News 24 report, I must actually just reflect this, Tami. The News 24 report says that the weapon that was used to kill Senzo Meyiwa has been linked to a man who's currently serving a jail term sentence in a Johannesburg prison, and that he was also responsible for the killing of an Alexandra taxi boss. So it's very interesting to see whether or not then who else this evidence will be linked to, and whether or not then it will still be linked to Longwetwala, as the long-standing belief has been that, of course, he is responsible for the death of Senzo. I think for many people, South Africans at large, you know, Orlando Pirates supporters and those who love Senzo Meyiwa, the biggest question has always been, why has it taken the police so long to get to the bottom of this when there were so many witnesses in the house? And you'll even remember that the family reached out to AfriForum to take this matter up prosecutorially. So we know that the police had concluded their investigations, but it was up to the NPA or the likes of the AfriForum taking up the matter and investigating it further. So now it seems as though the NPA, according to the News 24 report, is actually going to make a final determination on what to do with this matter. But just to go back to the family, Tammy, because it's been 6 or 7 long, painful years, because they believe they know who is responsible. And again, they've emphasized that police haven't been forthcoming with information. Let's hear what the mom said at the time as well.
So it's kwenzeke iphutha bafike la sikhulumisana ngabe lecala liphelile, ngabe mhlawumbe noma lo waboshwa wagwetshwa basinikeze basize siphile siqhubeke nempilo njengabo nje bephila kahle. Baphila kahle bona, thina siphile kahle, siyasokola.
Ngibaziya ngiyababuza amadoda yindaba sizokwenzani ecourt. Sethi nabayi asazi uNtanzi lapho kusho ukuthi ubuze ukuthi ndoda ngani mina ngiyaqala ngisho ukubona nje konje yena igama ubani isibongo ubani achazeke nje hayi no ukuthi ngaboshwa la kanje achazeke nje i-story sakhe achazeke nayo cha yena wethengiswa u3 million ukuthi uma ngabe ngafike ecourt ame ngathi kusho ukuthi abantu abenza lokhu yithi manje sebefuna abanye abantu asebezobhala ngabo into enjengedocument fair.
They're not the perpetrators. I think this will be a big slap in the face, because then they'll be like, what the hell have the police been doing?
Bayangibopha bayangithatha lapha esitratini engimkhona lamajika bangena up until ngize ngivume nami hayi ngendlela bangishaya ngawo vele bangishaya ukuthi bayangibulala noma yini ngifuna ngani so ngize ngivume ngithi hayi kulungile sakwenza lokho mina ngithi ngikona malume cause malume uzokwazi abazali bami ukuthi ngikuphi ngiyaphi noma ngiphi uze ukuthi bona no awufuni ni wena ukuyobona abazali bakho 99.
Phones, I went in for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from you.
They took them from us, and then
the criminals, I mean.
No.
Okay.
They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flavor and Masichaba Ndlovu.
We welcome you to The Drive, Longwe. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, you know. I mean, it was a robbery gone wrong, you know. I was even the coward of the day because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then that's when the guys actually released the gunshot, and that's when the bullet killed Senzo.
It really pains me that, you know, people think that I'm hiding something on the Meyiwa. Can you hear me?
I can hear you.
Sorry.
Still. Yes, I can.
Yeah. It really pains me that people they're tarnishing my name on a matter that does not involve me. I was not part of the 8 suspects, including my son, when Meyiwa was murdered. I was sleeping at the time when I received a call from Zoli, and then I actually went to assist KD because she said, please come, Senzo has been shot. That's all what I did. But now people, especially in social media, haters, angry people, they attack me. They think that I was part of it. I even listened to the advocate, Advocate Tefo, whom have sent me messages and on text. If you can see the messages that this guy, and in fact, at first when this guy sent me text, I thought it's not a normal guy who's talking. The content doesn't make sense to me. You know, he said to me he was representing the Meyiwa family on the Senzo case, and he wants me to make a statement. And I told him straight, I said, I was not part of the 8 people. That I think the people who knows the truth, it's my son, Kelly Kumalo, and the rest of the guys who were there. Because those people, Kelly, my son, and if they have conscience, and then I mean, they cannot actually. Someone cannot be shot in their presence, and they're all silent about it. They know who killed Senzo. My son knows. Kelly knows. Everybody knows. Not all the people in the social media, including Mr. Tefo. The 8 people knows who shot Senzo. I must be excluded, Cody. I was not there. I'm not part of it. And I'm not going to protect my son, Cody. I've said it before. If my son is the murderer, trust me, I'll come out there in support of all the people who actually want the perpetrators to go to jail. I will never protect him, Cody. I don't care how I love him. I love my son, yes, but if he's part of the people who murdered Senzo, definitely. Even if there's a death sentence, I will support it. It would definitely be strange if they don't call them. They have to call them because they're the ones who know who shot Senzo. There's no other person who can tell South Africans the truth besides them.
And Kelly Kumalo, when she called you on that day of the 26th of October, what did she say to you? Do you still remember her words?
She was traumatized. She said to me, Senzo was shot. He's shot. Someone shot Senzo. She was very traumatized, and I was shocked, you know. And I jumped out of my bed. I drove straight. I even called Dr. Ivan Koza on my way to Fosloras, where Kelly stayed. I didn't even know her house, but I actually didn't go to her house because they said they had left. They had taken Senzo to hospital. So I actually met them at the hospital. Everyone was traumatized, including Senzo's best friend who came on the same day. Senzo went to pick up his friend. Remember, when Senzo passed on, he went to pick up his friend, I don't know, in Park Station, whatever, from Durban. So this man was present when Senzo was shot. Hence, I'm saying that why would your best friend not divulge who killed Senzo? I mean, that guy is Senzo's best friend. What I'm saying is that Senzo's friend, I believe that he can. I don't know that guy. I've never met him. I've never even seen him once. I've never called him or what. I don't know him. He must tell the truth. He was there. He was there when Senzo was killed. And if that guy can say it's my son, the police must immediately arrest my son. Send him to life sentence, whatever they want to do. I won't protect him. I won't even bail him, totally. I'm telling you right now. I won't even bail him. What I wanted to say that I believe that, you know, if the police can interrogate all the people that were present, clearly my son and everybody, and ask them, they'll get the truth. I don't want to actually say that they're responsible or not. I think that's the police job for them to find out.
Yes, guys. Hi. We are just I'm just playing something so that we can just well up the 45 minutes because they are on an adjournment for 45 minutes. Guys, I don't know the procedures that we have seen so far are not actually all right. They are not followed very well. All the procedures that actually took place, they were not fine. This guy was having, how can this guy be with listen, let's talk. This guy was with Ntanzi for 17 hours. You know what was his reason? He said his reason was so that he cannot be bored inside the cell. So he took him out for 17 good hours. 17 good hours. They drove to even Ntanzi's workplace at Sibanye-Stillwater to confirm whether he had been working on that day of Meyiwa's death. What. Mogane further disputed the allegations of assault. Like, he refused that this guy was assaulted and all these things. I mean, Noxie are saying, why would Kelly call him? And we want a recording of a call between him and Kelly. We want to hear the exact words Kelly said to him when she called him. Yeah, definitely. I mean, that one is so interesting because they didn't call the police. That's the thing. They didn't call the police. Rather, they called Chico. And why would they call Chico? Which means there was something that has to do with Chico. That Chico has to actually know at that particular time exactly. Yeah, that's the thing. That's the thing. And all these things that took place on that particular day truly doesn't actually make sense. If you hear Chico very well, he said he went to Kelly's house and then he said, Chiki says, I don't even know Kelly's house. I met them at the hospital. And you can actually see that there is a lot of anomalies here. There's a lot of things that are not making sense. Mambato is saying, I think the recording of the calls between Kelly and Chico has been erased. Chico is the mastermind. Gininda, Chico, yeah, they planned it because remember, they went to his house. Not like you're saying, you are answering Nox, you're saying, well, actually, you're saying Lebala. We will never hear that call. Gininda already deleted it. Yebo. That man, I know very well that you can't get the proper records. That's why you can see Baloyi is running out from procedure. Baloyi is trying to dodge procedures. So now, Rata now who is Basson versus the state. Today we are having Basson versus the state. Rata is actually saying, no, let's look at the law. Let's allow. So he is allowing Mshololo to actually do what she wants to do and actually come up with the things that she has to come up with, so that they can actually get clarity. So I like that. I like that part because at least there is that thing that allows this to be fair. There is that thing that allows that fairness to come. Yeah, that fairness is supposed to be there. So guys, you can actually see that, okay, fine, when you look at it, the information that was given by Mogane, who was the police officer, who actually said they were driving because he wanted to. Do you think all the prisoners that are in prison, they also receive that type of treatment? Haibo. Parker is saying paperwork was shredded, so the recording was also deleted long time ago. And are you aware that this man has been there for a long time? This Baloyi has been there since this case started. So he has actually seen some loopholes. He has covered some certain loopholes and all these other things. Guys, hey, it's a lot. Somebody saying we need to pray hard. Truth must come out. This is draining. It's too much now. That is Tandos. You are actually concurring with Vili. Richard, yes, it's actually dragging. Tirello, you're saying Kelly tells Chico and Koza, the person who killed Senzo, they hid that person's name. Wow. Interesting. Simpio, you're saying, I wish to see the face of Gininda or even the picture. Yeah, that's the other thing. Guys, let's do profiling of these people. If somebody has got, yeah, it's live. Emmanuel, how are you? It's live. We are waiting for them to come back to court. It's live. We are on right now as we speak. Guys, I was saying, let's get a profile. Let's profile these people. Any information you can have, just inbox me. Just send it on our WhatsApp line. You have the WhatsApp line is there. It's appearing on the screen. Just WhatsApp. Just send us a WhatsApp and let's actually hear the. Let's profile them. Let's profile them. Let's have their information of. Let's have their profiles. I had some things about which I even posted on the page about some stuff of Longwe. I posted it there, and this current situation as we speak is on drugs, and it's too much, it's taking a toll on him. I need also the profiles. I need some profiles of these people. You see, Netflix did a lot. Netflix actually, they did quite a lot. They actually did serious interviews. They interviewed these people. They actually went deep to actually gather certain truth and certain information that the police actually is hiding. And this is something else. I don't know what's your take. Yeah, court is about to start. I'm not sure because they said 45 minutes, so now it's already 11:05. We want them to come back. It's already 11:05, and they are supposed to be back in court now. So I'm just waiting to hear from them when they resume. That's the thing. Want them to resume anytime from now. So, but guys, like I said, send me information that you have regarding these individuals, whether it's whoever it can be, whether it's Gininda, whoever it can be, that you think it's necessary for us to profile. Let's profile them and let's see who they are, really who they really are, so that at least we have a clear picture of who are we dealing with here. Somebody was talking about it and said that the person it reminds him of the former police commissioner Bekicele. That one was more of a mafia himself. Van der West, you're saying the judge must recuse himself. Yeah, somebody's actually thinking that the judge must recuse himself. But this one is better than the first one. The first one, I felt like I want to just go and pull him out of the chair somehow. But the first one was there. Yeah, that one was worse. The first one who was there was worse. I just think the one that we are having now is much better than the one that was there before. Guys, like I said, I need information. If you have got information, whatever you can send me regarding to these people that we are talking about. If you have that information of Gininda, whoever it can be, anything that can help us in this case, whatever that you meet along the way in the streets of social media, please just also send it to me. I'll be grateful, because I really need to profile. I need to make something. I need to make a profile of this case. We need to actually iron it out so that we can get a prolific file of everyone. Kamkhelo, you're saying, why don't they bring a white judge? It should be over by now. If they brought in a white judge, I'm telling you, this thing would be over by now. It was going to be over by now. Nyoni, you also agreed with Kamkhelo to say, why don't they bring a white judge? Nyoni saying, can we have a white judge, please? It's something that we need to actually talk about. Definitely we need to talk about it, because honestly speaking, the brown envelope is actually working, guys. I don't know if you agree with me that the brown envelope is actually working. Did you see these families? They were promised monies. Imagine how can you go and promise somebody 100,000? What is 100,000? I mean, what is 100,000, guys? Going to promise them 100,000 for them to take a fall for murder. Guys. 100,000, 100,000 icon. Another one was promised 3 million. So you can actually see that these guys I mean, they are playing with people's lives and people's destinies. I mean, it's bad. It's very bad. It's very bad. I know sometimes people can be in a point of desperation and they need money, but you can't take a fall for somebody and then you go to prison for something that you did not do. I mean, there are some people, yes, who are doing it. They will be told, go to prison, we'll take care of your family, we'll take care of your children, we'll take care of everything. And yeah, so at the end of the day, some people are just in prison, not because they've committed it, but they've taken a fall for someone else. They've taken a fall for somebody else. You can send your voice note, guys. You can send your voice note. I can play your voice note, or even a WhatsApp video. You can send it, and then I can play it for you right now. But I think we are getting to a point where we have understood certain things and certain flaws of our justice system. I don't know if you have got still trust in our justice system. As far as I'm concerned, there's a lot that needs to be sorted out. There's a lot that needs to be sorted out. Camo, I'm not sure. They are not at back. Can't tell how long is this 45-minute break. You know, this judge, there's a voice note. Let me see, who is it from. Kantilipi idokete lapela isonto lingaveli. We didn't see it. Hey. Hey, we didn't see that docket. There are some documents that were actually requested yesterday, and we need them. There are some dockets. Yes, there's some things that we need. There were some things that were requested, and we didn't see them. I don't know what is happening here. There were some things that were requested by the court. Yes, we did not see those things coming in. Yeah, the week has actually lapsed, and we haven't seen the documents that were requested. We haven't seen the documents that were requested. Some of the documents. Do you still remember that there was a document from the court? Not from the court, rather. There was a document. There was a document that was from the bank. The bank statement. We still need that one. It did not come to the court. We did not see that one at all. So I'm not sure now what exactly is happening here. I'm not sure what exactly is happening here. Definitely we need yeah. We need to see. We need to see, definitely. Let these things come out. We need these things to come out, and let's see how it's going to be like. Yeah, because guys, this thing it's actually eating. It's actually eating up most of our time and everything, because they are not actually giving us what we want. Yeah, we must call Julius Malema to come and align this judge. 45 minutes is good. Let me call Julius Malema. Let me call Julius Malema. Julius Malema will actually speak over this matter. Let me call Juju. Where is Juju? Let me call Juju here. Let me call Juju. Let Juju speak.
And no one has ever written an article about that. She's not above the law. She's not the law. She has a duty to respect her. This is unacceptable. We have 2 hours today. If anything, we should have started here on time. Justice must never be delayed. Never. This is an absolute rubbish. We must never settle. If it means prison, let it be prison. But no one must disrespect us like that. No one. No magistrate, no prosecutor must disrespect us like that, and then we keep quiet. He has never been early to any court. He says, come at 12, we come at 12, she's never here. She's never here. We must not talk because we are scared to go to jail or being disrespected. Can't be. We have rights, and our rights must be respected. It's a load shedding. We're starting at 11. It doesn't matter what time you start. You start at 1, you start at 2. She's going to be late. and then no one must talk about it. 5 years with here. He has never been on time. No journalist has ever written about that. No journalist has ever spoken about ill-discipline or coming late to court. Coming late to court, must keep quiet. 2 hours today. If anything, we should have been here, all of us on time, because we don't have time. There's load shedding. They said to us here 2 hours today. We have lost the whole day, 2 hours. Now it's gone, it's 1 hour. She's still not here. I'm not that type to keep quiet when nonsense happens. Nonsense is nonsense. I don't care who's doing it, whether it's minister is absolute garbage. Unacceptable. We've been too quiet for 5 years. We've been subjected to this nonsense of disrespect. Can't be disrespected like that.
Yeah, we need these people to be serious with our time, guys. We need these people to be serious with our time. So, you want Ramaphosa to intervene. He actually spoke about it, and he said he's going to intervene before Senzo Meyiwa's father passed away. Pastor, you're saying why the docket is missing. Let that docket come to the court. Yeah, definitely. We want that docket to come to the court. Definitely. We want that docket to come to the court. Because there are many things that are not adding up, you see. There are many things that are not adding up. Kolani are saying that you saw actually 2 white people, 2 white men at Flora Center exchanging a briefcase, taking a briefcase with a lot of money. No, we are not saying they are not corrupt. I mean, where there is money, actually corruption breeds. Where there is money, where there is something, corruption breeds. Yeah, these guys are breaking, but now the judge is not yet there. The defense attorneys are there. Lindo, you are saying why police are so corrupt. Those guys are just arrested for someone else. It's obvious, but police are still testifying rubbish. Yeah, that's the boring part. That one is the boring part. That one is the boring part. That one is the boring part. Non-translator is saying under rata, nothing is being followed up. Docket, statement, etc. But if it's something compromising instead, ufuna the law that is against it, or uvemelana with it. Yeah, he agrees with it. He agrees with it. He agrees with some things that will come up against the defense, the defense attorneys. So we are having actually a serious time here, guys. But let's see, because today he has actually given time for Shololo to come up with a strategy, because Baloyi was interfering. Mzukizi, how are you? Good morning. Good morning. Kenneth, you're saying sorry. I am. Did Mogane came with the docket? Please update me. Nope, we did not see any docket from him. There's nothing that we saw today. Bonga, you're saying whoever is sweeping the floor must come to do mine. Look at this one. Yeah. Kenneth is saying icon data 8 data 6. Let's be patient, because they have to come back. We need to actually see what is happening. Kumalo is saying I saw Baloyi's face, looks absolutely shocking. Yeah, definitely. He's actually shocked because he was not expecting that to come. He was not expecting it to come. Baloyi is full of surprises. The guy that is there, Mogane, what Mshololo wants to pull out is that Mogane interviewed this person without documentation. You see, why were you interviewing him? We don't care about writing it or anything, but why were you interviewing him without following certain procedures? Because everything must be procedural. Because she is saying when you interview someone, there are chances of implicating themselves, there are chances of, so they need representation. In whatever they will be doing, whenever you are at the police station, you need representation. So that's what Mshololo wants to pull out, that these guys were not actually even represented. So Sbuzizo, Baloyi is actually shocked for sure. I mean, he's shocked. He's actually shocked. Mari, if you look at it, you discover now that he's trying to dodge certain bullets. He's trying to run around. Dr. Sjabang, you're saying we want justice for Tori Holikani. Tori Holikani. Yantati. Rifuna justice, monana. Rebata justice, yena. This case needs Leselo. Kiman Lisi. Who is this one? Tiso Utauma. What's that one? I don't know which one is this one. Why and love? We are saying why Baloyi agreed yesterday that Mshololo can continue. He even gave her the document. Boom. Today Baloyi doesn't see the relevance of exactly. Why and love? You are very right there. You are very, very much right there, because yesterday, if I heard him correctly, he agreed. He agreed, and guys, he agreed. He agreed, and now today he's changing his story. Nyoni are saying in the police fraternity, Gininda wears the pants and Bekitele wears the skirt. Definitely, because he's actually dominating and ruling there. He's doing whatever he wants. Look at how many police stations he has been commanding people to say, go, do that, go, do that, do that, do that. He's not the supervisor, he's not the station commander, but he's actually he's actually telling people what to do. Hey. Guys, these guys are, I don't know why they're delaying to come back to court. Where are they? Where are they? Where are these people? Where are these people? They must come back to... They must come back to court. They must come back to court. They must come back to court. Tabang, you're saying, but this case, it's not going anyway. The witness, they mention statements, dockets, pocketbooks, and notes. And when they are needed, they are all nowhere to be found. That's what has been happening. That's what has been happening. Actually, I don't know why this guy, Baloyi, is bringing up all these useless witnesses. We want people that way in their house. Notlandla is answering why and Lovu. Well, today, Ubonile, it's going to bury him and his witnesses. Why and Love, Nontlanta is answering you here to say that you have seen it by yourself, that this Baloyi is going to bury himself for sure. Kamo, you are saying Ntanzi was arrested for the Nongoma case, exactly 163-10-2018, but to this day, he has never appeared at Nongoma court. That's the thing. That's the boring part. That's the boring part, guys. That's the boring part. I don't know. Did you see that? Busi are saying they must change the interpreter. Yo. John, I don't know where Jonasi is. I don't know where Jonasi is. I don't know where our main interpreter is. I don't know where our main interpreter is. Nontlanta is saying, Sofelanjani, that case, it's done and dusted. But guys, are you aware that this thing, they are just wasting much of our time, but this thing is actually sorted out already. This thing is done already. It's actually done already. Like, I mean, it's done. We are just actually, we have concluded this matter. We now know who is who and what happened. And Kudu, how are you? How are you? Tolika not make sure. Not make sure. We are actually waiting for the court to resume. We are about to see, I don't know, it's supposed to have started. They said 45 minutes. Tabang, you're saying, I can't wait to see Kwabini as the provide of the guns, and Gininda and Mjiako. These three are my main men. Okay. Kwabini, Gininda, and Mjiako. These are my three men. Those guys, when they come in, they will start to lie as well. That's the problem. That's the problem. They will start to actually tell us a lot of lies as well. These guys, we are tired, Shem. Not like they're saying that in that court, Kutlalo, Gomut, they started with lawing Drakadla Manje, if the interpreters not translate saying that these people are playing with Moody there in the court. First they wished this one Drakadla, now the interpreter. No, they are busy. They are busy. That's why I remember Mngomezulu. There's a time when his throat went dry. Vembani, you're saying, but when are they coming back? Guys, please, we need Kininda now. Yeah, we need it. Lindy was saying, hi, Kodwa, Yoktenga, EKFC. Guys, but have you ever seen it happening? A police officer, we know all police officers, taking his money from his pocket, not state money, his money from his own pocket to buy an arrested person food and even drinks, to say what type of drink do you want, for what reason, for the why, for the what. It's interesting, guys. We hear these things, but sometimes when you look at them, you discover now that somebody is playing with our mind. Kodwa baloi inabo ini abanwana. I'm not sure. Serious, that interpreter is so boring, guys. We are used to the other interpreter. This one goes, oh, when I'm on instead of calling Gininda, they will call Gedem Tasha. As long as everyone is given an envelope, everyone can become a witness. With these guys, anyone can become a witness. Aye, guys, they must come back now. But Mark Kumalo, Kumalo, you see this thing of EMPD. They were EMPD, and they are doing most of the work of the SAPS. And there were also these other guys. Remember, there were also the other guys again from escorting what services and what. Guys, I don't know. Lankley are saying I'm scared for about Ntanzi because the Rata is always helping the witness. Is not good at all, and Rata didn't like Mshololo at all. Definitely. No, definitely. The moment when she comes, it's a problem. Nonsikelelo, you're saying Senzo must rise from death and act. Definitely. He has to. Guys, I need to see what is happening here, because these guys were supposed to be back by now. They're supposed to be back. I don't know why they are I don't know why they are not yet back by now. They're supposed to be back. Alright, there's a message that came in.
Sanibona ka-Viral News. Yela, bukani la. As-analyze nansi into. First, Those guys were apprehended for Usbiya was apprehended for drugs. Ntanzi was apprehended for a rifle. Nesibhamu nemeda yakwaNongoma. Okay, bobayithula abantu were apprehended for different crimes. Mara mase babathatha babafaka esitokisini. Jiki sebababuza ngecase kaSenzo. Niyabona ukuthi similarities kuyafana kuyahambisana. Okay, number 2. When they go to la bahlala khona, Ntanzi, they found a plastic bag emnyama with rounds of ammunition of a rifle. Isibhamu senhlokohlela yesesikhulu impela. Ngapha kumfana lo munye wakasibiya bathola nakena same plastic bag emnyama nama rounds of ammunition nakhona. Hayi man, ubuyisa inhlosi phakamisa amashiya iyafana futhi lento kanti why kufane konke kuyahambisana. Ebese kuba ke uJonathan ngapha uyashaya. And makushaya ngapha beshaya uJonathan beshaya uSibiya, uGininda uyavela futhi. uGininda shuthi uyashaya usuke sekazoshayelela isipikile uGininda ukuthi manje ke ngithi enza so. uGininda ngoba umphathi omkhulu principal wayo yonke le game kufika yena egcineni esezoshayelela isipikile. NakuNtanzi same wenza the very same. Hayi futhi uNtanzi strong ngoba lo ngapha ngoba mdala yena uSibiya wazwayimoshela nokuyimoshela. Hayi uNtanzi strong shema kodwa mawuzwe torturing yakhe nama hours akhe hayi ustrong umfo kaNtanzi. Hayi kunzima.
Thanks, Nonhlanhla. Thanks very much for this voice note. Yeah, guys, seriously, it's heavy. Yeah, Ntanzi is very strong. Definitely, he was actually tortured. He was actually disturbed. He was actually he messed up. There's a lot that actually took place here, and I feel for him because at the end of the day, all these things that have happened. And yeah, it's a lot. Like what Nonhlanhla has just said, this issue of this plastic bag, this black plastic bag with ammunition, it was found at his house, found at his place, it was found again on another place. Are these guys just moving around with plastic bags of money and of ammunition? Are they moving with plastic bags of ammunition? Tembelihle is saying true voice note. It's Nonhlanhla there. The other thing is when you look at it, all these things that are taking place. I mean, it doesn't make actually total sense. They went there. Advocate Mshololo want to prove to them that they needed a search warrant. You can't go and search someone. There's a search warrant. You can't just go and search. Where was the search warrant? Who gave you the right to go and search at someone's house? Even if you know that is a criminal, you must get from the court a search warrant. You can't just go and search someone's house without a search warrant from the court. So those things, we need to analyze them. Like what Nonhlanhla said, we need to open up our eyes, guys, and see how this system is actually affecting a lot of things. Tabang is saying Rata can't find the relevant act. No, Rata was fine. Rata is fine. He wants to prove to Baloy. He wants to prove Baloy. Yeah, he wants to prove to Baloy that, you know what, this exists. Because he could have actually said no, it doesn't exist. Because he wants to prove to Baloy that no, Mshololo is on the right track. Pester is saying the interpreter doesn't sound perfect, or is it me only noticing that? No, all of us, we are noticing it. No, we are noticing it from the onset. We've been noticing that. Tabang is saying as long as Rata don't find the relevant act to discredit Mshololo, the case won't start. Okay, now I understand what you're saying. Yeah, because they are trying to play around with this because. Yeah, to me, sometimes he acts like he's on the side of. Sometimes he acts like he's on the side of Baloy. I don't know, guys. But let's analyze this. I've seen many people on social media saying those guys are guilty, they must be arrested. All right, fine. I asked one of the guys to say, guys, those are the ones, they've been in prison, they are on other murder charges, they've got nothing to lose. Why can't they say, okay, fine, no, we have done it, you see, all right, that's it. On these other ones who are saying that, you know what, if you see, there's a video that I posted on our page. There's a video that I posted on our page. It actually shows you that when they first appeared at court, and the first time when they appeared at court, there were things that they could not actually speak. They could not speak. They could not do anything. Ntanzi, you're saying Rata is lying. He always boast about how much he knows the law and understand the constitution. He's delaying the process because he's aware that the defense is destroying the lying witness. Definitely they are destroying him. Why they are Tabanya saying as long as Rata don't find the relevant act to discredit Mshololo, the case won't start. Okay, I get it, I get that one. Why are you saying there's a law firm called Mjiako Attorneys? It's possible that its police officer is this alleged lawyer and had used the name of those attorneys. I wonder if there is no way that the defense can go to this law firm to check if there is a lawyer who was assigned for Ntanzi on that day. Okay. That's a new one. I didn't know about this one. Mageba is saying crony lady is just a poor mlungu. She can just lie under oath. Tawi is saying 5 accused. They have nothing to do with this case. That's the thing. Remember, there's somebody who actually put in the comment section about the issue of the case he was arrested, the one which was in what do you call it? The one that was arrested in Nongoma, and it was pertaining to drugs. All right, fine. They bring him to court pertaining to the drug issue, but when they are coming out to go to do a point out, they are changing it. They are going to false Loras, where there's the Senzo case. So I mean, there's a lot of discrepancies. Even if I did not do law, but as a judge, I can actually see that there is something that does not add up. Something is not make sure here. Something is not make sure. So when you look at it, the 5, because if let's say they like what other people on social media are saying, hey, they are, can't you see, hey, they are found with this, hey, he was not at work, hey, what. There's a lot of statements and a lot of people that are talking a lot of things in this social media streets. If you look at TikTok, if you look at Facebook and sometimes YouTube, you can discover there are people who are talking out of ignorance. They are not analyzing the way we are analyzing. Duduzi, how are you? Mshololo, with time wasting, she was supposed to introduce the law that she said is in the books. That was easy. No, they said they wanted Baloyi. Baloyi was arguing. She was saying it, but Baloyi was arguing. But if you see what Mshololo has actually put across, very simple. She said whether it was an interrogation or what, that document is necessary. That's what she's saying. She's saying that document is very necessary, but Baloyi is refusing. So the judge is saying, let's not argue. Let's not argue. You see, the good part about the law is it's written. There is something that it's written. Kamukhelo, you're saying, I will not be surprised when Ramaphosa fired Rata Mokgatleng. But I don't think it's necessary to fire him for now, because to me, I can actually see some balance. I don't know if you saw it. I actually see some balance. Victor, you're saying no choice for all police. They have to do anything to save Gininda. Ndini. Kenneth, where are these guys? I'm not sure. You see, I'm looking at the judge seat. It's empty. There's no one. The judge is not yet there. I'm sure he's busy taking the Basson Law of 1979. Tabang is saying, so far, there is nothing or evidence that shows beyond reasonable doubt that this case this case, where was I? This accused have committed this murder. What we see is that this confession and pointing out was made under duress. Yes, it was made under duress, and it was actually done without following normal and proper procedures. That's how it is. Shauza, how are you? We are waiting for the court session to come in. Tembetli, they are saying, yes, Ginida is a snake and poison. Yeah, definitely. Kenneth, I'm actually waiting for these guys to come so that we can resume. Chauke are saying there's no doubt that a person's privacy is violated when police conduct a search and seizure without a warrant. But in terms, okay, there's no doubt that the person's privacy, yes. But in terms of Section 22 of the Criminal Procedure Act, the police can search and seize without a warrant when they are reasonably sure that they should have been granted a warrant, and that the delay caused by getting where was I? Granted a warrant, and the delay caused by getting the warrant will defeat the purpose of the search. But as Notch says, what is reasonable is not clearly defined, and must we establish on a case-by-case basis by the courts, and that the courts have so far not established a list of factors that would be regarded as reasonable grounds for executing a warrantless search. Thank you for that. Thank you for that insight, Chauke. Thank you for that insight. That is clear. That is actually an in-depth thing. Chauke is actually saying that sometimes they just come in and do what they are supposed to be doing, search and do all those things. That is when it's a reasonable type of thing. But if it's not reasonable, now he's actually also coming back and he's saying, but now in this particular one, the thing called reasonable is not actually coming out clearly. The reasonable part is not coming out clearly. Let's hear this. I think it's Mduduzi who will send a voice note.
Hayi madoda aya. Ngike ngasho ukuthi umama umshololo uyathanda ama delaying tactics. Hayi man. Ukudla isikhathi? Hayi. Lapha bekumele nje yena introduce ilaw evumelana nalento ekhulumayo. Only it was simple as straightforward. Mngomezulu yilo into ayazi. Mngomezulu akawathanda let's adjourn my lord. Manje umshololo since ngesikhathi sabotifu. Let's adjourn my lord for 15 minutes. Let's adjourn for 10 minutes. I will make copies. Let's adjourn. Esiyabuya lapho sekabuya ngenawo lo mthetho futhi. Hayi Nkosi yami. There was no need yokuthi nabezofika ukuthi asokumele baletha ama head of arguments. Manje besiyawudla isikhathi manje besiyaphikisana ngalowo mthetho. Bekumele avela lethe ilaw esho njalo and yaqhubeka ngelokuze nini yakhe. Hayi man. Basidlela isikhathi sele data lethu la.
I hear you, Mduduzi, but if you check, you'll see that she actually said it, but now Baloy is refusing. Baloy is actually undermining that thing. He's undermining that law. He's undermining the law. She actually said it. I actually even said it. She actually said it, and she was looking at the document to say, according to this document, 1, 2, 3, 4, 5. But Baloy now was interjecting, and yesterday Baloy agreed to say, Mem Shololo can continue with what she wants to do. But today, Jiggy he changes, and then boom, there he goes south. Not only saying, you are talking about the judge. He must continue with the case, because if they change him, this case will never be solved, and changing of the judge will give Baloy new tricks, exactly like they did with the first judge, which gave Baloy new time and tricks, like bring a new witness like Uzungu. Exactly. Yeah, exactly. I agree with you, non-transfer, because the moment when we change the judge, we are giving Baloy time now to play around with these tricks and all these things. There's another voice note. Let me just quickly let me play this voice note quickly.
Ngiyanizwa abantu bakithi.
lento kodwa ake siyibhekeni lapha nje. Umugane uhamba nomsolwa, uyaliqeda uhambo noma indlela obekade eyisayinele emkhiphele yona. Lokho ayesekwenza ukuthi ahambe nomsolwa sonke lesikhathi wayekwenza phansi kwamuphi umthetho, ngoba ngicabanga ukuthi lokho ayekwenza ukuthi amkhiphele beye emsebenzini wakhe emayini beyofuna ulwazi ababelifuna babekwenza phansi komthetho. Lokho ayesekwenza-ke manje esuyasuka uyahamba uhamba zonke lezi ndlela ayihamba nomsolwa, uyahamba sonke lesikhathi usuku lonke. Wayekwenza phansi kwamuphi umthetho bakwethu. Asingadlaleni ilokhuzana, sidlale umogane. Umogane ucasha ngesithupha ebebonakala ukuthi lento yakhe iyabonakala ukuthi unamanga, ingamanga. So ekugcineni kwakho konke kumele ithole enkantolo ukuthi wayenzani kuphi sonke leso sikhathi.
I agree with you. That's where this whole thing is rotating. Where was he? What was he doing during that time? Where was this person? There's no much record to show. There's the occurrence book for certain places is not available. His pocket book is nowhere to be found. Some places where he's supposed to have actually signed in, nothing to show. So yeah, he's playing merry-go-round with us. He's playing a merry-go-round with us, definitely. Playing a merry-go-round with us. Because you are saying since yesterday, Mshololo caught the law. It's just that Baloyi is also a puppet. Not understanding. I don't think Ntanzi was detained in a proper prison. He was kept as it like an sub. That's listen guys, that's what we actually find. We actually saw that this guy was not actually in a cell. There was a time when he was taken out, brought in. Where was he taken to? They were taking him to their torture chamber where they can torture him and come here saying, married people don't listen. Baloyi is the one wasting time. He's objecting to the things that are on the paper. Exactly. It's not like Mduduzi. It's not like Mshololo is wasting our time. Mshololo. It's like we are just checking on the issue of he spoke about it yesterday. Baloyi agreed, no problem. She said she's going to come with a clean paper, then she continue with what she's doing. Jiki Baloyi starts to stand up and say, no, that is not supposed to be like that. Do you know why he's fighting? Bona, he's fighting because he knows that it's not proper, it's not constitutional, it is bad. It was not supposed to be done in that way. The things were not done properly. The things were not done properly. Hence, she came in with a new paper, not even written in Ntanzi, a new paper without any other thing. Okay, let's read. What does this paper entail? We are not going to be using what you put down, but just because in your chief evidence you said that you interviewed the person. You interviewed the person. That's the thing. You interviewed the person. So if you interviewed the person, there is a procedure. According to your chief in evidence, you said you interviewed him and he did 1, 2, 3, 4, 5. You did A, B, C, D. Right, no problem. Since you did that, so that interview, if Baloyi continues, is going to be scrapped out. So in other words, it will be a waste of our time. Mogane will be just like we have wasted our time. Mogane. Not like they're saying listening is a skill, darling, and people don't want to teach themselves to listen attentively. Yeah, because when you look at it, guys, we need to actually come to a point where we agree we need to come to a point where we definitely agree that all these things that are actually happening now, we are seeing fabricated things, fabricated stories. And look now, our time is moving because they just want to clarify a certain law. They want to clarify a certain law. And yeah, Mduduzi, you're saying Shololo since yesterday is talking about law of warning statement. It's back. It's back.
Your objection. What are we busy with for the sergeant here?
Indeed, my lord, that is the nub of the matter.
Yeah, what are we busy with?
We're busy with a questioning or interview that Sergeant Mogane conducted with a suspect.
Yes.
And
in the boardroom.
Yes, in the boardroom. In other words, we're not busy with the taking of a warning statement.
Yeah.
But just maybe an interview, an informal interview that a police officer had with a suspect.
Yes, that's the background to the issue.
Indeed, ma'am.
Yes, Mr. Mshololo, let me understand you. What are we dealing with?
My lord, we are dealing with the interview which took place between the suspect and the witness at the boardroom.
Right. It's an interview.
It's an interview.
Yeah, what about it?
Yes. Then, my lord, my submission is that because the witness said he explained the rights, he explained the allegations, and the accused responded. Therefore, that interview ought to have been recorded.
Right?
Yes, my lord. That's
if it's not recorded?
My submission, my lord, the court can make a ruling.
Yeah, fine. Is that what you are dealing with, and is that what your colleague is dealing with?
That's what.
Now, how does this form come into play?
My lord,
this form which you say the court must peruse.
It's because, my lord, this form says statement regarding interview with the suspect. Hence, I refer this witness to that form. And it says, my lord, on the first page, statement regarding interview with suspect, paragraph 1, my lord.
Oh, you're reading paragraph 1 where it says the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on a folio attached to the folio of that page. And folios must be signed by the suspect, the interpreter. So you are saying this form is applicable, in other words?
My lord, that's my respectful submission.
Okay, you want me to rule on that?
To say, during that interview,
it must be signed. The form must be signed according to you.
It must be recorded, my lord. Yeah. Although, my lord, I am not saying that the witness was bound to use this as it.
No, let's say the submission is that it must be filled, this form, or what is your submission?
Yes, it must be.
It must be filled.
My lord, can I just refer this honorable court to just one judgment?
Which one?
I'll be quick. I'll be quick, my lord. I won't waste the court's time.
Which judgment is that?
It's the Henry Foster and the Minister of Safety and Security. It's judgment by
Others.
Yes.
I've read this judgment.
Yes.
It's about damages.
Yes.
Unlawful arrest and the assault of a suspect who subsequently, obviously, the charges were withdrawn because there was not sufficient evidence.
Yes, but there's a principle that I want to bring it to the attention of this court.
Bring it to which principle is that?
Thank you, my lord. On page 23, paragraph 28.
Wait, I'm going there.
Yes.
Page. Wait.
Page 23.
Wait. Page 23.
Yes. Page 23. It's paragraph 28, man.
Paragraph 28.
Yes.
Yes, put it on record.
Yes, my lord. Paragraph 28, under warning statements, my lord, it says, express provision is made in every warning statement in this court's jurisdiction for the completion of a warning statement each and every time that a suspect is interviewed. Paragraph 29, the constitutional protection provided for in terms of Section 35 of the Constitution to arrestees is embodied in this principle. There is no justification for any interview with a suspect who has been arrested or called in for questioning to take place without a warning statement being completed. Paragraph 30, my lord. The very term warning statement indicates that a person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my lord, I have not finished. Yeah, I'll skip this. And then paragraph 34, my lord, the next page on page 24, which says, it was startling to hear that both defendants' witnesses who were experienced policemen believed that they were entitled to question the suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last reference, my lord, is just one paragraph before it goes to, I'll summarize it, my lord, paragraph 38.2. Paragraph 38.2, I'll be quick, my lord, wherein it refers to the warning statement which is headed statement regarding interview with suspect. Paragraph 38.2, my lord. 38.2. Yeah. Yes, my lord. It says the warning statement which is headed statement regarding interview with suspect. It is referred to as SAP S3M document and embodies 12 pages on the cover and on every first page under the insignia of the South African Police Statement. The statement regarding interview with the suspect. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my lord. There is no basis in law on paragraph 19, my lord. Paragraph 39. Yes, paragraph 39. There is no basis in law of fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not This is for the judgment of this case, my lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. Paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that a suspect may now be taken to court is to be frowned upon and not condoned by this court. It's
a single judge. It's a single judge who says that.
Yeah.
Oh, it is.
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I have read it into the record, it must be completed whenever there is an interview between
who must complete it?
It must be completed by the person interviewing the suspect.
By the police person?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the court of co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the court of co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trial of fact, and this court can only interfere with the finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he expressly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under it. Somebody interfered with it. Where's the fourth page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah, and then paragraph 92 reads, it's page 4. One of the main contentions still read page 19. Paragraph 88, sorry. He says, it is not necessary to set out the evidence adduced in the court below, as Manamela AJ has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognize the rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a bill of a right protected by the Bill of Rights leads to exclusion. See in this regard, as versus Ndlovu and others, 2002, SCA 70 2002 to SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC 8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that It does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice in ways that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia, as Justice Mtombo said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution. If, on the other hand, the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Christler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes.
So this case of Hodis, it's not the be it and the be all. I quoted you two constitutional cases where they say even unconstitutionally obtained evidence. Do you have that? Hello? He, Attorney General of the Transvaal, let's read it so that everybody knows it. Right? Do you have it?
Yeah, I'm just finding it quickly.
Yeah, just find it. Yeah, you've got this computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court cases.
Yeah, it has no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Leonard Friend is finding it.
No, but just find it. Because people, when they read the Constitution, they all say if the evidence is unconstitutionally acquired, therefore it is not admissible. You better go and examine the phenomena and the exigency under which that evidence has been acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order, and the perceptions of the public regarding the application of fairness. After that, we can conclude whatever cross-examination you
may
want.
other counsels be given opportunity to make submissions?
Yes, yes, no, everybody.
Thank you, ma'am.
Everybody. So Hodes has got a point, but the point is, as I understand the evidence of this witness, predicated on that interview, among other interviews, he repaired to Carltonville to go and further investigate. That's what he says, not me. When he got to Carltonville, Benita came and they went to see the personnel manager, and the personnel manager made a statement to them.
Can other councils respond?
Yeah. No, we're going to read this. We're going to read this, and then everybody is entitled to respond. Sorry, Ross. Let's go and fetch that case. 1996, Attorney General of the Transvaal. Oh, check it. Do you have it in your computer? Yeah, P. This is K-E-Y. This is Attorney General of the Transvaal, 1996, Constitutional Court. You got it. Okay. Yeah, that's the one. Sorry. You yeah, it's with us. My registrar found the law.
Yes, it's paragraph 23 of the judgment.
Yeah, paragraph 23.
It says at times fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Go on.
Well, and it says if the evidence to which applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. It will then be for the trial judge to decide whether the circumstances are such that fairness requires the evidence to be excluded. It follows that the applicant is not entitled to an order from this court in these proceedings, that the evidence secured as a result of the searches and seizures will be inadmissible in criminal proceedings against him. Yeah, I don't think the...
Yeah, read that tension. Why critical reasons like this?
Oh, okay.
Because some of us may not know it. It talks about the tension.
In there's paragraph 13. Says in any democratic criminal justice system,
yes,
there is a tension between, on the one hand,
that's it,
the public interest in bringing criminals to book,
right,
and on the other hand, the equally great public interest in ensuring that justice is manifestly done to all, even though suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties
stratagems
and ingenious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence albeit obtained unconstitutionally nevertheless be admitted.
Okay, yes, Mr. Mnisi. Mr. Mngomezulu, sorry. Any submissions?
Court, please, my lord. My submission, firstly, I would agree with the principle that each case is decided on its own merits. Under the circumstances of this exercise or this discussion, is that when we look at the interview that was conducted or was held in the boardroom, it was held under a different pretext from the officer. He was booked out from the police cells to the boardroom under a very wrong case, case 163 of 10/2018. When an interview is carried in terms of a docket that is the accused is now facing on the charges of case docket under 636. My lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case number 163 and changing tune when they are in the boardroom. So now the accused is no longer, as per the evidence of there's no evidence before this honorable court that accused was interviewed in terms of the Nongoma case. But all that we know before this honorable court is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is that fair for the accused in the course of administering justice to be taken by surprise to say, this is what we arrested you for, but now you are subjected now to these particular allegations. Please provide us. To what extent did the rights were explained, especially under case number 636? Second fold of my submission is that it's based on the evidence that is before this honorable court that at all material times when the accused number 2 is booked in and out, there's no indication, there's no entry that he was subjected to an investigation under case number 636. So that would tantamount to unfairness, and that will jeopardize to proper functioning of justice system. In this regard, as the facts are as matters are decided on their own merits, it is my humble submission that accused number 2, they should have actually gave him a clinch or an information. He's the one that he received an information earlier that he is involved in the murder case of Senzo. But when he is booked out, when the rights are read in terms of Exhibit LL, they are read under a very wrong case number.
Okay, thanks.
That's my submission.
Yes, Mr. Nisi. Yes, no problem.
As it is the court. But I think there's a bit of a confliction. A conflation of issues.
Yeah, I mentioned them.
Yes, man. When this issue was raised by my colleague Advocate Mshololo, and indicated that there is authority, or in fact, and each time a suspect is being interviewed, that interview needs to be recorded. Then my colleague for the state stood up and said, but that's not always the case. Then the court also got in and said, as far as the court understands the process, it's not a warning statement. It's only supposed to be filled in as and when the suspect is being charged. for him to be prepared for court. My colleague further insisted that, but that is actually not exactly the case. That is when this commotion or this argument actually started. In order to satisfy himself, then the court invited all parties to bring authority before court to support their submission in respect of what they believe in. The defense, my colleague, Advocate Msololo, brought a judgment that specifically addresses the issue that the court said, bring judgment, bring an authority to convince me. We were expecting the state as well to bring a judgment that will go contrary to what the judgment that has been brought by my colleague is saying. The state hasn't. Instead, what is happening now, man? We are trying to confuse two issues that are very distinct. Whether or not it is in the interest of justice, that evidence that is sometimes unconstitutionally obtained should be obtained or what. But this is not the crux of the investigation as to why we actually had to come here. In the judgment of Hodes SC, it's very clear. The statements regarding with the interview with the suspect, it's very clear. Each time there's an interview with the suspect, whether or not that suspect is arrested, this document must be filled in with no exceptions. I won't go back and what my colleague has said.
Yeah, I've heard you.
But now, there's also a referral to the case of, to what the Honorable Judge Prela said. These two cases are totally distinguishable because in the Prela case, my lord, it was not about whether or not each time that a suspect has been interviewed, this document 3M in brackets, small letter M must be filled in. It was only a determination on whether or not the statements that were used in those in the decision of this case should be used against the accused person in this case or what. So these two cases are totally distinguishable. As I am standing here, I am still expecting the state to present to the court an authority that says no, it is still fine for a suspect to be interviewed without having to fill this SAP 3M in bracket M. The state is not forwarding such information. So basically, we are not saying, my lord, that the court should make a decision here and now.
I'm not going to make, I'm not confused. I'm not going to make a decision now. You're arguing the law. I'm going to make a decision at the end of the case. You're about to say, hey, judge, ladies.
That is what
I'm listening to the principle of the law. And the decision which I will make will be predicated in the sense that I gave all of you a chance for the input of the very issue which is being debated in this year. But I'm not making a finding. I'm not making a ruling. Never.
Yes, my lord. That is basically would have been my next point.
That I'm going to make a ruling.
And no, I intend to say, my lord, that when my colleague, Advocate Msololo, raised the issue of the interview with the suspect in the boardroom and whether or not this form was filled, it should be something that should be, my colleague should actually be allowed to proceed with that form of cross-examination. It will then only after all the evidence at the end of it all has been heard.
I said
then
that,
the court
ask your colleague, I said that to her. Didn't I say that to you, Msololo? That I'm not stopping you from going ahead with the strategy of the cross-examination you are forced on. Didn't I say that?
The problem is that when
all I said, you admit that this form doesn't have statutory application. That's all. And you said no. But I never said to you, stop your cross-examination. Never. I will never say that to any country.
My lord, after I've been granted that leave, my lord, the state objected.
No, but I decide whether you continue or not Mr. Baloyi. Okay.
If the state objected, then the court said we must make submissions. That's where we are in, my lord.
Yeah, fine.
Thank you.
Yes, Mr. Numalo. Oh, are you still on?
No, I just wanted to wrap up.
Oh, I see. Okay.
Therefore, my lord, it will be very precarious. Actually, it will be a precarious procedure to, at this point, decide this thing as if it is final.
Who's going to decide it? I told you I'm going to decide at the end of the case.
The reason why I'm saying this, my lord, is because I hear already there are authorities that have been referred to which do not specifically deal pertinently with the issue that the court has raised.
Yeah, in other words, you and Mr. Shololo and Mamalo and Mr. Mngomezulu, Baloyi, at the end of the case, they're still going to have to argue
as it please the court,
about the admissibility of these statements and confessions and pointing out how much.
And more particularly with regard to that interview that was held in the boardroom where the form was not fit. Thank you, my lord.
At this stage, I had two contrasting legal submissions.
Yes.
That's all.
Thank you.
All right. Yes, Mr. Nimaru. Thank you, doctor. And I may just add, other judges just keep quiet. They keep quiet and then yes sir, yes sir, yes sir, and thereafter they come with a decision. I don't do that.
Yes, that's
I don't do that.
But should not only be
Yes. Yes, Mr. Mumala.
My lord, my starting point will be that it is not enough for the police to use the SAP 14A, because we've been hearing that the SAP 14A was used, that is before and after the accused, that is accused number 2, was at the boardroom.
That's a guideline.
Yeah, as a guideline. I'll re-emphasize and follow the decision of Holtz SC to the effect that whenever the interview is conducted with the suspect, it must be recorded. And the statement regarding interview with suspect form must be used. I'm having the understanding, my lord, that if that is not followed, then it violates the accused rights in terms of Section 35 of the Constitution. And therefore, in terms of Section 35(5) of the Constitution, it stipulates that evidence obtained in violation of the accused rights must be excluded if that, or the admission of that evidence will render the administration of justice into disrepute. This form gives an obligation, it's an obligation to the police to say whenever the interview is conducted with suspect, this form must be used.
Yeah, I agree with you. You see, it's incumbent upon you as advocates of this court to make representations to the Minister of Justice, to pass regulations,
yes,
addressing the very exigence.
Yes.
It
looks like there will be a number of representations.
Yes, you have a right, as that's how the law develops.
Yes.
Then there's a lacuna in the law. The persons who practice in this court must take it upon themselves to address that lacuna so that the Minister of Justice, Lamula, must address that. Because it's going to recur. That's why you have 9 provinces and you get 9 different decisions in all the 9 provinces. Okay.
Thank you.
Mr. Mtolo, you are continuing.
No.
You are continuing with your cross-examination.
No, but you're still waiting for this.
No, you are continuing with your cross-examination. Is that not so?
Yes.
Yeah, now we listen to Baloyi. Remember, I said I'm not deciding the issue now. I'm going to listen and hear all of you what you say. So Baloyi must say whatever he wants to say. Thereafter, you continue with your cross-examination. Okay. Is it so difficult, madam? Yeah. Yes, Mr. Baloyi.
Mr. Court, please, my lord, we just want to come from a slightly different angle. And we raise an objection based on purely issue of evidence, of relevance. You know, my lord, we objected on the basis that the questioning is not relevant in the sense that my learned friend was pursuing a line of questioning that says the accused number 2 made a statement. From the evidence that has been given by the witness, I'm not even sure if one can put it as high as that to say that the accused made a statement. What we have before court, my lord, is
made a denial.
Yes, it's evidence by Sergeant Mogane that says we convened in the boardroom with the accused. I warned him according to his rights, and as a suspect, I informed him what the purpose of the interview was, and the accused gave an explanation. I don't know if one can say that it's a statement. He gives an explanation. He says he doesn't even tell him about the date on which the offense was committed. He says, I'm investigating the case of the death of Mr. Senzo Meyiwa. And the accused then, out of his own volition, says, well, I know about that matter. I read about it in the newspaper. Is that a statement? We submit with the greatest of respect, my lord, that if one looks at the form that my learned friend wishes to use to cross-examine this witness, it refers to some sort of a formal statement. All that Sergeant Mogane was doing was to offer the accused number 2 the opportunity of an explanation, and he says, I was at work, and that defense is pursued. Suppose, my lord, for one moment, that if the explanation that the accused gave that he was at work, if the cloaking records confirmed his version, that would have been the end of the matter. There would have been no need to pursue the matter any further. It could have never been the intention, and even with the judgment that my friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to embark upon, that should be followed. These are just preliminary issues that are aimed at establishing whether a formal statement or a statement should be obtained from the accused at a later stage, and which happened in this case, my lord, after these preliminary processes. A formal statement was obtained, to which the investigating officer will refer to when he testifies. It can never be in the intention of the judgment by Judge Waters to say that in every instance where there's that preliminary inquiry, that this formal process should be embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect, it envisages a process where a formal statement intended to be taken from an accused. And if one looks at the discussion under this topic, it all results under section 217, which deals with the confession. So we submit, my lord, that the intention here with this form and with the process that my learned friends wants to embark upon is, if, or in the case where a statement of some sort has been made. We also want to refer to the judge's rules, my lord. We know that they have, as it were, been taken over or subsumed by the Constitution, but these rules still serve as a guide.
What is that, 1946?
Yes.
1940
and 1931.
41.
Yes,
they
were approved at the conference in Cape Town in 1931.
Yeah.
And the writer Himstra describes the purpose as follows. He says, These rules are administrative directives for the guidance of the police force. And it says the judges' rules are mainly of historical interest because they are longer in effect. Their role having to a large extent been taken over by the norms in the Constitution. The following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in section 35, which distinguishes between an arrested person and a detained person. And section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against the person. So if one looks, once again, my lord, this buttresses the point that we have the view that in this instance, one cannot really say that the accused made a statement, because if one looks at subparagraph C, says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in section 35(2) pertaining to a detained person. And in this instance, the detained person also includes a suspect who's in custody, as it was held in the Sibanye case. But to come back to the judge's rule, rule number 8 says the caution to be administered to a person, in other words, that is got a right to not to make a statement and what the consequences thereof is or are, says the caution to be administered to a person in custody should be to the following effect. And the rules distinguish between a person who's formally charged and a person who's not formally charged. In the case where a person is formally charged, it says, do you wish to say anything in answer to the charge? You are not obliged to do so, but whatever you say will be taken down in writing and may be used in evidence. And we submit, my lord, that this is what this form caters for. And paragraph B says, where a prisoner volunteers a statement otherwise than on a formal charge. In other words, in this instance that we're busy with, if the accused volunteered a statement, and here the judge's rule refers to a statement, where a prisoner volunteers a statement otherwise than on a formal charge, the warning that should be administered should be to the following effect. Before you say anything, I must tell you that you are not obliged to do so, but whatever you say will be taken down in writing and may be given in evidence. We submit, my lord, that what we are currently seized with, it's not a statement, just a mere explanation, an alibi that the accused gave that he was at work on the particular day, which was subsequently followed. And we submit, therefore, my lord, that this form that my learned friend wishes to make use of is irrelevant, purely on the basis of evidence and should not be used.
Yes, thanks. Yes, Mshorolo, can continue.
Should I continue?
Yes.
I see the witness.
Oh, okay. You want to talk to Mr. Baloyi?
I was asking to address the court before the defense asked a question. There is something that is bothering me, my lord.
Okay.
Lekabule.
Mabane gore go pe jore ke tlele pampiri ya di case be re dira mabane.
Yes.
Yesterday, the court asked me to bring a document of cases that we were doing.
So, in
I brought the documents as the court has asked me.
Ke ngwetse ka mokamela twe be re dira le mabitso a batho ka mogare.
I've written down all the cases that we were doing and the names of the accused. I also gave it to Advocate Baloyi contained in an envelope. As we were sitting and during the break, my lord, I saw the document. When I handed it over to Mr. Baloyi, it was written confidential. However, I saw the document now roaming around in court, my lord.
Who else had that document?
I saw Muzi in possession of it and all the accused were reading it.
Who gave them that? Do you know? Wait, let him have his say. Who gave it to?
I do not know who gave it to them, my lord. And now I am being worried, my lord, for our witnesses, especially in those cases. And some of those cases also affect some of the accused. I would not mention them by names. And in all these cases, my lord, there are firearms that are involved. People were shot. People were kidnapped. And other people were threatened. So I was worried if my witnesses would still be alive tomorrow. As I am saying that, my lord, there are a couple of case numbers there.
And computing system computer system SAPS
it is possible that they can go into our SAPS computers so that they would get the names and the addresses of our witnesses.
Advocate Mngomezulu tele pampilo ro winchiche mo sistibinyare na ka case ya Nongoma.
I saw saying I am not accusing Advocate Mngomezulu, but he brought a certain case which he got into our system of a Nongoma case. And it shows accused number 1.
And more the mutom chedi nyone ke bone ngwetse Sergeant Mngomezulu ke tsona ke lokola ga bona.
On top it shows that a person that has retrieved that case is Sergeant Mngomezulu. I'm not sure if is that sergeant related to him or not.
Hello, ke ba ke tshogore na ba banga ba ka sone go ntsha information yo ka mokgona e kireng ga gona.
So thus I am afraid, my lord, that will others not be able to retrieve the same information as he received it as well.
And the thing is, Musa, which I ever was in keep I didn't
Pala bucha bona na go ke tla le pampiri e belia ba emedi or e belia ba sorry bana.
And I would also like to ask, when I brought that document, was it for the defense or was it for the accused?
It
was for the court. Actually, I'm shocked. I'm shocked. Because that document is supposed to be perused by me first. Because I'm aware of the Intelligence Act, that certain documents are classified. I'm aware of it. I've dealt with cases like this in the past. Even when apartheid was applicable, where you approach a judge in chambers, and the judge makes an order and reads it in chambers to the presiding advocates. But because we are so-called in a new dispensation of transparency, I made it in open court. But that documents, or those documents, are not supposed to be seen by anybody except me. First. Are you with me? No. And I was trying to avoid a situation where in South Africa people and judges are accused of being bought, being captured and all that nonsense. And I was going to familiarize myself with that information, having regards to the Intelligence Act and protocols. And I would have decided what information, having regard to the proceedings here, has to be divulged to the councils here. Are you with me, sir?
That is understood.
Mr. Baloyi, what is your excuse?
There's a good case, my lord. The document was disclosed to my colleagues in line with what the court said yesterday, that it's only meant for the eyes of the court as well as the defense counsel.
No, but they say the accused were reading it.
Yes, well,
they got it obviously from the. Actually, I'm shocked, that senior counsels like this can actually behave in this matter. I'm just shocked. I explicitly said it's only for the court officials. Now you're telling me the accused are having. This gentleman is right when he says he doesn't know whether tomorrow some of the witnesses will be dead or not. Because this is, unfortunately, is a type of case we're dealing with, unfortunately, where people are said to be shot, etc., etc., etc.
I've just asked my learned friend to give back the copies to minimize the impact that there might be. The copies will then be.
Mr. Mngomezulu, what's your view now?
My lord, I would like to exonerate myself from.
Hello?
I would like to exonerate myself. I've never consulted with the clients or with the accused.
Where did your clients get the document? Or did it?
No.
Which client and which accused?
Musi le ka mogana one ba go ba ka netse mara ba ile beletse ka mo ba le ba sere pampiri jo ka mo
Muzi and all of them, they were.
Who is Muzi? Accused number who?
Muzi.
Number one.
Accused number one, man.
He was reading that document.
He took it and he went towards them, and they were all together reading the document.
Yeah. And Mr. Nisi?
My lord, I feel a bit uncomfortable when the court says, and I'm saying this with utter respect for the court, when the court says the court is shocked that senior counsel such as us here.
If it's true,
we do
yeah,
such a
right.
despicable
Make a mistake.
It is indeed despicable.
If it is true.
Yes. But what worries me is, I don't think statement that has been uttered by the court in the circumstances where it has not been determined exactly what the circumstances were through which this accused person were able to see that document. It's a bit appropriate, man, because now it seems as if all of us they just decided to stand up and give these documents to.
No, fine. You can tell me.
Did
your client see that document? So
I did not consult with my client this morning.
Did he see? You don't know if he saw the document.
I don't know whether I saw the document.
Mr. Mngomezulu?
I'm not so sure. Why is this witness worried about the statement that he has made? Because in his own statement that he made on the 25th of October 2023, he refers to one of the cases where.
No, that's obfuscation. Do you know that word? Obfuscation. Hello? Do you know obfuscation? OBFUSFUCATION. Obfuscation. That's what you're doing. You're dealing with a present situation. You're telling me about an affidavit of a person who you say.
No,
we're talking about a court order which said he must bring that information and it mustn't be made available to any other persons except myself, maybe, and the council. Now you're talking about.
Yes. Then in that information that he provided, in his statement, I'm saying in his statement, he refers to one of the cases that are detailed in that document that he provided to my colleague this morning. One of the cases are referred there in his own statement that he made. So I'm failing to understand, my lord, how I have.
You don't even know what cases he's referring to in the document which he wrote. Maybe the very case you are quoting is not of any moment according to him. Are you with me? It's like the Ngoma case. You can mention it because we have dealt with it.
The court is not understanding what
I understand fully, sir. So your client have access to that document? This court. Hello?
I did consult with my client.
And you showed him the document?
I consulted him based on one case that is mentioned in that document.
Did your client have access to the document which I said the sergeant should write for my own perusal?
Yes, he did, because I had to consult with my client based on the case that the witness has documented in his own affidavit. The consultation was based on that.
Ms. Mshololo, what's your view?
I ask back leave to consult with my client because I personally have not read that information.
You are not aware of that information?
Of that information, but may I just clarify from my client if he...
Yeah.
Thank you. Thank you, my lord, for the indulgence. My lord, I have not read or consulted with my client regarding the document that was given to us by the state. And my client informs me that when they were grouped together with accused number 2, 4, and 5, they were reading this document, my lord. Or maybe if I can just show it to
It's
my
not the
lord.
one that is prepared by.
It's not the one, my lord, yes. And they are indicating the page that they were looking for. Where
Whose document is that?
It's an indictment, my lord.
Oh, they were reading the charge sheet.
They were reading the charges.
Which they've been reading in the past 3-5 years.
No, my lord, but that's what.
No,
was
I
happening.
hear you.
Yes, yes. This is
Where's that confidential document, Mr.?
The document
Because
they
now
were
we're
reading?
getting respect that now.
Sorry, my lord, can I just get further instructions, my lord? I see the hand is up for my client.
Yeah.
Thank you. My lord, just to add, my lord, as to what were they discussing in this indictment, my lord. It says they were discussing about witness number 104, who is being referred.
Now they can discuss the indictment. No problem. There's
Yes,
no problem.
I just wanted to be clear
Fine, I appreciate
as to
that.
what is it that they were discussing in
This
this.
inquiry is about whether or not this order which I made has been exposed.
Yes. Those are my submissions.
Mr. Aloy, where's that document which you given by?
I'm just trying to get all the copies from my colleagues.
My lord, before the copies are being taken back, with due respect, my lord.
I want the copies which the gentleman, the witness, made to be put in the same envelope, which was supposed to be for my eyes first. You know, during apartheid, I must say this, we had apartheid judges in these treason trial cases, where a judge would make an order that an investigating officer should do what I did. And then he would say that the order is just for the court. And even the counsels who were in court would never ever be aware of that order, because the judge then had a discretion whether to disclose that information or not. And invariably, he never disclosed that information. Now, we think we've got a democracy here which is functioning. And then court officials will know what to respect when a judge says that order is made to divulge certain information which is not supposed to be made available to the public. Just check whether all these documents are the ones which you... Do you have a copy of the original document?
No, can you feel it?
How many?
The original document.
I gave Mr. Baloyi the original document
And I did that copy.
and he made copies for himself.
So there was one document.
Okay.
Okay.
I do not have it. I said he should do it for me.
Is it Gininda who will know? Just listen to me. Is it Brigadier Gininda who will know under which section of the Intelligence Secrets Act these documents are categorized?
The go tlo kgonagala gore le tsebe gore ditokomane tse di mo sectioning e feng.
It's that you don't more secret service and crime intelligence.
I am informed that they are on the Secret Service and Crime Intelligence.
Okay, can you bring those documents?
Yeah.
In the nature of things, these documents are not going to form part of these proceedings because that evidence has now been contaminated. And this court has got a discretion to decide whether to make these documents available, as I originally intended. Because from what this witness is telling me, if I do that, some people's lives will be jeopardized. I'm not saying that. He talks about people being killed. He talks about guns swirling around. He talks about kidnapping. He talks about whether his witnesses will be safe and alive tomorrow. So this court makes a ruling that this information has been expunged from the record of these proceedings on the basis of the fact that it may jeopardize other persons' lives, which are more important than the life of this judge. Okay, Ms. Michelle, let's go on.
Can I ask that we take the long adjournment and now resume after lunch?
What's the time then?
I think it's 2 minutes after 1. My lord, we're debating the issue. Is counsel now going to proceed?
Yeah, I'm going to proceed with the cross-examination.
Along the lines that she was doing.
Yes. But the only order I made is that this confidential information
Horo e re ditokomane tsela tse le tsatseng tsona ba ni jwale horo e tlo di swara ka lebaka la mabaka a betšeng le fane ka ona e be go bolelwa ka maphelo a batho.
Okay, ukuthi usayitshela walethela enkantolo kazopitha enkantolo ayasasetshenziswa kuzolunga.
Just for my own edification, where are the dockets?
The docket di kae?
Docket ya Fosloras. Since Vaisha decision, I saw
case number?
The case number even
534.
That's our Polo case number.
What's the charge? What's the charge?
Yeah.
Molato wa bona be di
For dealing in drugs.
dealing in drugs matter.
Yeah, it's 534 if I recall. 534 of 6.
Horo e re e ka re ke 546.
And the other one?
Yengwe.
Nongoma 160 of 10.
And this one it's for Nongoma 160
of 10 2018.
of 10
160 of 10 2018.
Yes.
Where is the docket?
Normally Kishila Gay my lord was Kennel Ginda we will some rota level.
I did not get it where I left it, as Colonel Ginda said he will come and look for it.
And the other one?
Yengwe guy.
No,
Those are the two that the court needed.
Okay, 2 o'clock.
My lord, can I make one submission, my lord, with due respect? I know the court has ruled, but it is my request that that information that has been taken back from us, it must not also be kept with the court.
Why not?
Because that information is coming from the witness.
Did you hear the ruling I made?
Yes, my lord.
What was the ruling?
That we are not entitled to it. The order was that the witness must bring this information for the court purposes.
Right.
Yes, my lord. My request, my lord, is that the information cannot come from the witness direct to the court without us having been given an opportunity to look at the information that is submitted before this honorable.
I thought you had seen it, all of you. You just gave a copy. Didn't you give a copy?
I have not seen it, my lord.
Okay,
I have not seen it, my lord.
This information will form part of the proceedings of this. Just give it.
As the court
So that if this case goes somewhere else, the judges in the SCA and the judges in the Constitutional Court will have access to this.
As the court
I'm not so naive as to take the information which has been led to this court and go and keep it in my sitting room.
Thank you, ma'am.
Hi guys, it's too much here, it's too much. There's been an argument in the courtroom and yeah, it's been quite a lot and something has been taking place here Mogane now is coming with an issue accusing these defense attorneys of divulging the information to their clients. So now they are saying no, we did not. They were actually discussing on something on their indictment and something like that. So he was adamant to say that no, they were doing it like that and this and this and this. So guys, I don't know what you actually think about it. What do you think about this case today? What do you see? What's your findings? And what did you actually see? I've got a live stream. I've got not a live stream. I've got a voice note that came in during the time when we were having these arguments going on. Let me just play the voice note. I want to hear what this one is saying.
Azophela ukukhohlakala kubalo uzifunde ndu kubi kube ndodeni izinto ziyambhedela zihambe kahle.
All right. That was a voice note that we were having there. I'm telling you, things are now going south. Actually, in the court, there are some things which are now going the other way around, because at the end of the day, now this guy is turning around, telling us another story. He's coming again and he's saying to the judge, no, the confidential documents were shown to the accused and what. Now the judge was a bit angry at all the defense attorneys. So Mnisi came up and he said that no, it's wrong actually to say those things without you getting clarity on what really transpired, because he was just bashing them and he was just saying things. I mean, Mtobisi are saying this judge is really biased, unprofessional, and lack reasoning skills. Definitely anger issues. Lindoya saying, Shololo, I like a top defense. She's simple, defend from high. Why are you saying the witness is just trying to shift the goalpost? Definitely. Henry, you're saying this Mogane is a liar, man. Yes. Kenneth, you're saying, Lord, no docket, Gininda will come and look for it. Ow, Nkosiam. It's clear they arrest Ntanzi with the wrong docket, definitely. That's why the docket is nowhere to be found. I've seen it. Bulelani, you are saying it's classified documents can land in court, open court on the 5 accused. Where is your comment here? 5 accused, it says about court official Mr. Baloy with experience, okay? Filele are saying Shololo. Now, guys, you see now, that's the thing. This thing is actually, it's actually left, right, and center. Bonks, you are saying spot on. The witness lied about documents read by suspect, and the judge saw it and changed his mood without telling the witness about his lies. Yes. Yeah, the judge has actually seen it. The judge making accusations even before he established. Bongani are saying delaying tactics. They can see that the net is closing in on all those involved in this case. I don't get why Baloy is defending pure lies where we are being subjected to. Opa, you're saying Rata has already found the accused guilty. Body language speaks clearly. Jimmy are saying Ipoisa elikhulu just lied inside the court of law. Ipolisa elikhulu. All right. So guys, I don't know what you think. Lerato is saying he's buying time. This guy, Baloy knows about this. Yes, definitely Baloy knows about it. And if you check, he actually mentioned that he gave these documents to Baloy, and then the documents started to go otherwise. So let's see after lunch when Shololo comes in, and let's see how it is going to go down, because I know that it's going to be something else. So guys, let's see. We'll come back again. After lunch. You can actually send in your voice note. I can actually be playing your voice note in the interim. I agree the pin on the same accused sitting before court if the docketers went for decision at the DPP, then Baloyi as a state prosecutor can inquire about it and get its status. Okay. Now this guy was even accusing Mngomezulu. He was saying there's another detective Mngomezulu, what, or is a sergeant or a constable. I don't know what he was actually talking about in the issue of Mngomezulu. Vusi is saying this judge do have anger issues really sometimes. Something's wrong, either at home and he's too old. He just resigned because the more you go older, the more reasoning, the more your reasoning capacity deteriorate. Because Nadia saying this man is on something, I can see. Simba is saying Mohale and Baloyi are continuing on playing mind games, as it is obviously no docket. And if you hear Mohale clearly is shifting matters to Gininda. Exactly, I saw it as the one who removed it. Yes, I saw that one. I saw that one as well. Let me just play this voice note quickly. Let me just play this this voice note quickly. There's a voice note that came.
Sanibona ma-advocate amahle. Hayi bo ngeke. Ikhona inkinga lana. Umbhemi lo ofakazayo manje ayibuseshintsha izinto manje. Uthi the confidential document iphethwe o-accuse. Sekusuka umsindo ke manje ongasuka umphansi ijaji lishoti manje lishoti ukuthi i-confidential ifika lapha bameli ninike bani into. Egcina sekuvela ukuthi indictment statement. Like iphepha ngade lokuphethe icala lawo. Accuse nobani bese belibuka bonke. Akuyona le confidential isebaloyi la umakhulu. Ubaloyi akasasukumi kodwa into engidida out asho ukuthi hayi my lord anganiki umuntu mina le confidential. Angayinika wama lawyers. Noma ama lawyer ngabe senikwe kodwa akukho la kuthiwa wanike khona ababoshwe. But sekusuka umsindo lento isikhala ngokuvikelwa ngani. Lento isebenzisa lokuvikelwa ngoba kunale information ayifake phakathi abalekayo nokuthi bekubala ngoba izinto akazitholanga lo mbheki. Nangibona ubaleka nalezi zinto ukuthi akayithola zebala ukuthi u-intelligence ugininda kanje ubalekela le nto yakhesana ngokuthi ya document engakabuyi. Ngisola ngathi mina isizofakwa kulento ye confidential ngoba lapha kunabantu abangasavili. Ngoba sithinteka document yaka Mngomezulu ukuthi Ntanzi we-accuse bani ngenkathi kugwetshwa ukuthelisa. Lethu sifika nezitora ingeke asekho safe mose enkantolo ngoba yazi inkosi enkantolo izokhala minyembe sithi ha uqinisile you must keep guard ukuthi ama witness are safe ngoba yapulawa la abantu basejele baboshiwe yiphi witness abazoyibulala babe babulala yiphi witness laba abantu bekuyibona baboshelwe ukuthi babulela uSenzo banamapha amandla okuthenga abantu ukuthi akubulawa ama-witness yiphi witness eyabulala ngoba ozungu bebeyiwokhela all the part 9 years bengenankinga wonke ama-witness abeyiwokhela bonke othumele bebeyihambela nokheli bengenama-bodyguard yimaphi lama-witness ebekuzothiwa ukheli uzosikhomba yini hayi guys mina sengiyacikeka manje hayi sengiyacikekile bahambe boyiplana lento ukuthi yedlalela faka everything tikujela manje wena ukuthi noma kuthi confidential vele ukuthi naye ngiyibona ifundwa lapha igebengu kushuthi abantu abawufaka lapha i-confidential ngavele idize nje fast kanti laba bantu hayi ufuna lixolisa ijaji malibuka ukuthi I'm sorry ukuthi ngithathe ukuthi leya ncwadi ngoba sekuvele enyinto ukuthi le ncwadi akuyona le confidential leya seyifunde ekugcineni ujaji cha le ncwadi ngeke ifakwe the case ngoba inezinto ezibalekile zabantu abangahle babulawa akusashiyo ukuthi akasashunqa ukubheka ukuthi hayibo bengithi le niphethe ngiyaxolisa hayi gazi kudlalwa ngathi lana le case engibone gazi ifuna ukudecide amakubona athi yangala ibuyiswe ngenkani ifakwe ehlathini manje kuthiwe lo muntu nesingake sayikhuluma kule case ezimbhaqayo ukuthi wrong funa kuzothiwa si confidential fucking man I'm sorry ngenhlamba.
Right, no, I agree with what he's saying now. Imagine, guys, if this document that they are saying is confidential, even if these guys can see the confidential documents, like what he's saying, how are they going to go and shoot those people? They've been in this place for a long time. Who do they know? Where will they go? The only people that can be dangerous in seeing these documents are the people who are already outside, not the people that are inside prison. These guys are not coming from home. They are coming from the prison house. So how can they actually be a threat? That's the argument this one is saying now, because how can they be a threat? And the documents that are needed, they are not found. There are things that are needed, they are not found. And the thing that is with Kininda, it's another story. Mogane, you are saying they are playing with us here. They are playing with us here, and I agree with you. They are definitely doing that, and it's actually frustrating. Policy are saying my Lord will not apologize. He is also working with them, which is all this has been seen long time ago. Yeah, it's quite hectic, and definitely it's quite hectic. Somebody sent a message and said this police was arresting wrong people. Yeah, definitely. You're also sending a voice note. I want to hear what you have sent in. There's another voice note that came in also. Let me just play this voice note.
This man is hiding something, I can tell you. But iqiniso lizovela baba. Lizovela iqiniso. Hayi kuningi abakufihlayo lo muntu, kuningi akufihlayo. Why manje elo kangaka lama documents akawalethile? Kuningi okusazovela mfethu la. Kuningi okusovela. Iqiniso nje lizovela. Lento abayenza benoGininda isazovela la enkantolo.
Yeah, that is true. The truth is definitely going to come out, and we can actually see that the net is closing on this Gininda and these people. There are things that are actually showing now that there are signs that this thing was actually also a fabrication, and now they don't know what else to do. This is a delaying tactic. They don't know what to do, and they really don't know what to do. And this case is that this guy is claiming to be investigating. I really want to, I'm also curious. I want to know what exactly is he investigating. There's another voice note. Let me just quickly play.
Guys, come on. You know, the judge always takes sides before listening to the whole story. Now, you just been told that there were some confidentialities which were going through the accused there and there, blah blah, and without hearing the side of the story. Did you see the reaction? He was already furious to all the advocates without even listening. So I can see this guy is biased. I'm telling you, he's taking sides. He doesn't even want to listen to Mshololo or hey, I don't know what's going on with this judge. Yo.
Hayi sanibonani. Hayi mina ngokwami akho intruder eyangena yabulala uSenzo la. Umuntu wabulala umuntu owayesendlini. Sekulahlwa nje icase ithathe kushiftela iblame kubantu abangenze lutho ngoba eSouth Africa vele mawungenamali kuba nje usithulela kuyinyanga. Kahle nje ayikho le case yalabantu baboshela ubani. Uyabona nje kahle makukhuluma ubalo ijaji inyakazisa ikhanda. Makukhuluma defense judge uyambotha against defense ngayo yonke indlela. Kahle le case ayikho. Kufanele ngabe khishwa le docket 357. Iyona ke impela ngabe iyalokhuza ukukhulunywa ngayo. Manje abona ukuthi akwahlala ngengane zabantu siboshela ubani ingane zabantu kodwa kuyayiwe ezulwini.
Guys, did you hear also what Baloyi was saying that time? Baloyi was saying that when this guy was arrested because of that case, and when he was asked that, do you know about the Senzo Meyiwa case? Then he said, yes, I know. Then he started volunteering to make a statement. You see, that is not proper. It cannot happen in that way. How can somebody who is arrested on drugs say, no, I know about that case. I'm also part of it. I can actually give you 1 or 2, 3 statements. I can speak about it and everything. I mean, it doesn't make sense. You can't just jump in and start to say, I can confess. After committing a crime, you can't just come in and say, I'm now confessing because I've done A, B, C, D. Guys, these people are playing with our mind.
Bhuti yabona lento le lo Baloyi lento le uyazile ukuthi izokwenzeka, so manje batrya ukuvimba ukuthi at least le witness isheshe iphume manje la elento kwi stage kungasabi nalento kwi witness box ukuthi kungasabi nemibuzo eminingi avoid ukuthi manje bayabona ukuthi umshololo uzogubha aze athole lento bayiplanile kahle ukuthi whoever uzoqala ukwenza lezi zinto bazokwenza kube ne distraction then bakhona ukwenza yonke lento le.
No, they know the story. Definitely, they know exactly what they are doing, and it's just a delaying tactic. And they know that Mshololo is actually giving them a tough time. Remember, all these advocates, all these other advocates, they are new. The only people that were there when this case started was Mshololo and Baloyi. These were the first people who started. I saw a video on their first court appearance. Mshololo was there and Baloyi was there. The first court appearance. During the time, I'm sure it was the time of lockdown or somewhere there. The first court appearance, Mshololo and Baloyi were there. That's why Mshololo is actually coming in and speaking even on behalf of all the accused number 1, 2, 3, 4, and 5. There's information that she knows. There's something that she knows. There's something that she actually has that these other guys are not having. So yeah, let me just listen to this other voice note that this one is saying.
Ya ngiyanizwa madodana nithi lamajita basephakathi bazobulawa ubani lama witness lezi ndoda izinkabi indoda ayinkabi zisebenza as a group then mawubhambe abanye ungacabanga ukuthi ubabhambe bonke labaseleyo bazosala bakwenzele nyakanyaka bazosala bakubulala nje uzodliwa ungazi ukuthi udliwe yini. Uselapho nje mfowethu kude point olusho lokuthi wavela wathi ngangiyiphathi umbuzo ukuthi zonke igebengu bafethu siyazazi masenze amacala afunela so uqale wanika ama direction umuntu wayimfonela noma seshilo ukuthi uyasoleka lo wayimfonela uyamnika ama direction cha sendaweni ukuthi uzongithola kuyona sengibuza guys umuntu ofele usolwa isiphi isigebengu na hayi kasi ngiyaqala ukuzwa ngesigebengu esithi sifuna sibambe incingo sifonele just uhlala sisho ama direction umsolo wena ecaleni elukuthi no kathi wathi kushiwa izolo nje ukuthi wafona lo wesifazana oqala wamfunela umsebenzi thepha walandela lo munye walandela wesizwe wathi mina ngumseshi ngifuna ukwazi la uhlala khona ngecala melo kulala umeyo uyamnika ama direction lo muntu ufana ne110 usabamba incingo usaphendula usanika umuntu onjalo unika ama direction bafethu ezazi ukuthi umbaleki ngofuthi wafika lapho watholwa futhi azange afice senyamalela ukho la kuthiwa zathi yafika kuyena wabhaleka guys umuntu owenza icase noma imuphi uyabhaleka laba kaze babaleke laba bebabantu bazibanjelwa nje labo bazifuna ekwadlalwa ngathi bafowethu kwadlalwa ngathi emzansi ngiyayilanda le ndawo ethu ngimzila ubalo eselevela lento emshayile ukuthi leyancwadi yafuna noma abi case wenza interview bese ibalekele selevele sethi hayi lapha yayibahlekile umthetho uthi ngoba lo wabuzwa wathi uyayazi lo case wayibona TV uyiphathi yayi should we volunteer ukuvu we yayi shit man.
Yeah. You're saying here on Facebook, you're saying you saw them reading from the file. It's only now he's raising a concern. That's the thing now. Why now? Because he said, no, there's something which was disturbing me. Somebody saying, no, it was Baloyi's tactic. Come on, hello, you're saying these police officers have been all promoted after 2020, after the arrest of this accused. And you're saying, look at him acting. The state should be the ones accountable. Exactly. Yes. No, they're trying to get rid of Mngomezulu just like they did to Tefo. That is Aubakwe, Gino Jane, Henry Villakas. You're saying Mogane has all the efforts to fight back. Remember, this guy. This is the right. You're saying this is the right what? This is the right hand man of Gininda. Hence, everything is with Gininda. You know, I always wonder how, as the community, we can actually, you said immediate here, police or intervene here. Police is a flop and liars messing the police reputation. We have no justice here. This case is fabricated and surely they discuss it every night. Let's get Gininda now. We are sick and tired now. I think we need to speak to him. We need to sit down with Gininda. Charlie saying I will not be surprised if Mshololo gets death threats. Wow, yeah, that's another thing. Chauke saying Mohani came up with a plan to make sure that the judge withdraws the evidence. He was advised accordingly what to do and what to say to make sure such cases are not followed because they were not going to prove his point. Why he kept the accused number 2 for 17 hours while the investigation took only 4 hours. Guys, if he was actually moving around, because these are the cases which he was moving around with this accused. So we need, it's actually, but look, it's something that actually this one is aware of, and it can be used as well to say, guys, you were moving with this guy. Did you go to this place? Did you go to this place? Like that's what he said. Agnes, they're saying, Joe, I'm really shocked. But anyway, leshanuli niti hadikopani kan niti Agnes tinto zena hadikopani. Serious. All right. I have another voice note. Where is this other voice note? Is this one or what? I have another voice note that I need to play here right now. I need to play a voice note here quickly. Let me.
Uselapho nje mfowethu kude point olusho lokuthi wavela wathi ngangiyiphathi. Umbuzo uthi zonke igebengu bafethu siyazazi masenze amacala afunela so. Uqale wanika ama direction nomuntu wayemfonela. Noma seshilo ukuthi uyasoleka lo wayemfonela. Uyamnika ama direction cha sendaweni ukuthi uzongithola kuyona. Sengibuza guys umuntu ofele usolwa isiphi isigebengu na hayi kasi ngiyaqala ukuzwa ngesigebengu esithi sifuna sibambe incingo sifonele just jethu uhlala sisho ama direction umsolo wena ecaleni elukuthi no kathi wathi kushiwa izolo nje ukuthi wafona lo wesifazana oqala wamfunela umsebenzi thepha walandela lo munye walandela wesizwe wathi mina ngumsethi ngifuna ukwazi la uhlala khona ngecala melo kulala umeyo uyamnika ama direction lo muntu ufana ne110 usabamba incingo usaphendula usanika umuntu onjalo unika ama direction bafethu ezathi umbaleki ngoba futhi wafika lapho watholwa futhi azange afice senyamalela ukho la kuthiwa zathi afika kuyena wabhaleka guys umuntu owenza icase noma imuphi uyabaleka laba kaze babaleke laba bebabantu bazibanjelwa nje labo bazifuna ekwadlalwa ngathi bafowethu kwadlalwa ngathi emzansi ngiyayilanda leyo ndawo nje ngimzwile ubalwese levela lento emshayile ukuthi leyancwadi yafuna noma icase wenza interview bese ibalekele selevele sethi hayi lapha yayibahlekile umthetho uthi ngoba lo wabuzwa wathi uyayazi leyo case wayibona TV uyiphathi yayi should we volunteer ukuvu we yayi shit man.
Yeah, hi guys. Yeah, we do understand guys ukuthi le case le inzima kakhulu involve abantu abaningi ngaphakathi, but sifanele sibheke nokuthi like izolo the witness uyowayikhuluma no lama case la sinawo, even the accused maybe utla amanye ama case bangawazi ukuthi ahamba njani, then so basenzani basaphenya ngawo ukuthi ama case avelele after. Yeah. So but uze nayo le nto lezi bamcele zona izolo, then so but now the papers is just going around. Yeah, it's easy for us to judge ukuthi witness onamanga or wenzani, but I'm telling you guys siphela kwelinye lizwe lana. Remember a lawyer ufanele ugcoke isikipha esiyellow ukhona ukuphikisa magistrate ukuthi lesikhipha sikho yellow si red yena wenza umsebenzi wakhe. Once you win the case uphumile kuyo ukuthi abubani bazosala balemala abana bazobuhlungu ngaphandle is a problem. Yebo. So sifana sibheke lento leyo. Let's not be quick to judge ukuthi no this seyiso thina sivele sithathe ukuthi no ya ngempela abayenzanga or benzile. No one knows. You understand? But iqiniso lizophuma ekugcineni.
All right, Bafo. We are not judging. We are just analyzing. We are not just judging. We are not saying anything. But if he's lying now, that becomes a problem. Because if he's lying, it becomes a problem with us. Because somebody said, why did he come in with that story now? Why did he not just say before the court starts, I have a problem, this and this and this happened, judge, you promised me 1, 2, 3, 4, 5. Why now? And if you look at it, the issue, like the other one has said it in one of the voice notes, to say even if he had shown the accused, how are they going to execute a judgment on those people? And for what reason? Is it in line? Are they witnesses who are witnessing them or what? There's something that, is it their case? What is it that they are talking about here? What is it that they are talking about? Are they talking about other cases which involved the same suspects? I don't know, guys. Hence I'm saying we need to I like your view to say that we need to be neutral. Yes, we are neutral. I agree. We are very, very neutral. But what we just want is let them say it in a truthful way. We are neutral for sure, but let that truth actually be validated and let it be straight. That's my thought. But I agree with what you're saying. We are very much neutral and we are not in a judgmental position. We are just analyzing things. Let me just take this other voice note.
On this case, for Mpofu a ka kenella a thusa mo a thusang teng es ke a bona vele go ba batla go ntsha Mngomezulu the way go leng ka teng je ba batla Mngomezulu a tswe ya ka tefo a tswile. So I'm thinking ke kopa fela my wishes Mpofu go ga ka kenella mo case re bone go tletsagalang then judge e tswe man go kene batho ba fresh. Kena batho ba fresh man tlo tlisa bontate mogolo ne le ntate mogolo o le yanong ke o mong gape ntate mogolo mong gape. We are not going anywhere. Next day is going to be like this again. Hey.
If they bring a fresh person, a new person, it's another story again. We start afresh. If they bring a new judge who is young and whatever, we are starting afresh. It starts again from scratch. They will start again from fresh. So that's another problem. Ketile Kumalo, you are actually responding to that voice note that I played earlier. You are saying that we are analyzing with facts, Budi. Yes, that's what I was saying, that we are just analyzing with facts. It's just like we are just going through things. So, Sisi, the thing that you have just said now of us getting young people to come on board and who can actually deal with all these things, it's good. But now, remember, these ones are experienced as well, and the young ones who can come in, it will be also starting afresh. We'll be starting on a clean ground. We'll be starting afresh as well. It will be like we are starting the whole thing from scratch. Atlantis Kosana, you're saying that was a plan all along, because he made up that he was investigating many cases, which is a lie, which is lying. Next, Mshololo was going to ask for timesheets, notebooks, entries, all the works. Hence, I'm now seriously doubtful of this judge. Everyone is for sale in Mzansi. But he refused. Did you hear the judge says that I don't want this myth of saying everyone is bought. The judiciary system is under a brown envelope. You're saying the judge, the state, and its witnesses are in cohorts to protect Kelly, Chico from prosecution, and everyone for perjury. That's Nonhlanhla Skosana. Nkosinati Tubela, you're saying, I know Gininda won't come now because they see all fingers pointing on him. They will try another delaying tactic. Yeah, definitely. If Gininda comes, guys, I'm telling you, it will be 2 weeks. 2 weeks of Gininda only. 2 weeks of Gininda, because that one will be will be actually is on everything. Is on everything. Everyone was reporting to Gininda, and I don't know when Chico and Kelly are coming. That's the other thing. I'm sure when Chico and Kelly are there, I'm sure we will actually be having almost 1K or 2K views, because people want to hear what those two are going to be saying, because they've got a lot to answer. I don't know if they are going to be called anyway, because they are also needed. They are going to be called. They are going to be called. I think the defense is the one that is going to call them. If you look at Baloy is calling people that are not necessary to come. Baloy is calling people that are not necessary to come in. But yeah, it's a yeah. Come here, we are saying Hari Nerina le white judge ukebe usna the witnesses tengata. So he's saying that if we're having a white judge, we were not going to be having too many witnesses like this. The witnesses are being called by the state. Baloy is the one who has been calling these witnesses. So even if the white judge was there, he was not going to have control over the witnesses, because Baloy is the one who is actually picking witnesses. Guys, we started at 100, 110, 106. I'm not sure, 100 something witnesses. Can you imagine? So come here. Even if it was a white judge, it was the same, because it was going to be Baloy's call, because he has to submit his own side. So guys, all right, let me just do something quickly, and I'll come back to you now. Who has got a banking app? I need electricity. Who has a banking app who can buy me electricity online? Send me a WhatsApp if you have a banking app. I will send you the meter number. I'll send you the meter number now. Who is going to do that? If you have an app, you can just do it while I'm talking, or else I have to go and buy electricity now. Let me read this comment here. There's someone who is saying that Tefo warned someone about his monkey tricks, and people said he was mad. Look at what is happening. The state is trying to disrupt the proceedings by all means. Yeah, they are doing that, and they are doing that. Yeah. Kamehele are saying no. The final decision, Kiamang. The final decision, Kia judge. Akiri judge is the one who normally comes with the conclusion, but still, it's not just a conclusion that will come. They are going to argue again. This one, they will argue like this. After this, there's another argument which is coming at the end before the final judgment. The judge has to bring in the final judgment at the end. So, Kamuhelo Mokitimi, the judge is actually going to give the final judgment at the end of the day. So I think we are learning law. I think I am now learning law. But this thing of Basson of 1979, of Basson versus state, and what versus state, and what of 1970 something, it doesn't work now, because we are now having amended laws since 1990. Is it 1999 or 1997? There are new laws that came in, amended ones, which actually have got rights, dealt with rights. So those ones before that, they are under apartheid regime. So yeah, it's something else. So guys, I think now we can just quickly take a short break, because they are about to come now in 20 minutes time. Definitely they are going to come back now in 20 minutes time. Mopai as an advocate, therefore, was right about everything in this case. Yeah, that's why they end up pulling him out of the case. That's why they end up pulling Advocate Tefo, because Advocate Tefo was actually having information, a lot of information. Advocate Tefo was having a lot of information about this case. He was like hands on. So they made sure that they pull him out of the case, because he was actually disturbing their plans and what they were doing. So they pulled him out of the case. Yeah, I don't know why, but he had a lot of information. And they pulled him out. That's why he even wanted Baloyi to come out. He also wanted to start a trial within a trial. They refused him. And there's a lot that he wanted to do, but they refused him to do so. Kamahele are saying, can't the judge stop Baloyi about so many useless witnesses? I don't know if he tried to do that, because right now it's another witness after another witness. Useless ones on top of that, useless ones. The ones which we don't even need here, because we only need the people that were in the house. Those are the ones that we need. Anything will start to grow from there. Yeah, we'll start to now move from there. We now get other people. I want to play for you the family of the accused. It's so long. While it's almost time now. So by the time it's time up, we should be done. So let me just play, and I want you to see what was promised to these families. All right, guys. Pastor, you're saying all the accused are not involved in Senzo shooting. The 7 people who were in the house are involved, yes. Bongeo, you're saying Mogane, Sly, Haibo. Mogane is a liar. Haibo, how sure he is that those papers are the same one he gave Baloyi? Rata, he should ask that before he was shocked. He ruled that those documents will not be used as ubufakazi ekubeni umkano ube namanga akuona. And if you look at it, guys, you discover now that this guy, yes, something is fishy here. Okay, Bongiwe, it's true. If you look at it, you discover that the judge just reacted. He didn't actually think straight. He just reacted. Come here, they are saying, and they are all promoted after arrest of the accused. All right, guys, let me play this. This for you.
Chico, I want you to hear what Siyabonga Mia had to say to us yesterday for your benefit, and who had been representing the pair and 4 others.
Kulungile. uNkulunkulu usabele wasipho kubi nathi abanye abantu ebapho kuhle. Akekho umuntu ozalela ukuthi angazuzi ngengane yakhe. Nathi sibheke okuthile ngomzakhulelwa njengoba ngangithi umzakhulelwa ngangilandela ukuzaleka kwami mina uqobo. Ngacina ngithi-ke namhlanje ngizele umzakhulelwa uye yedwa indodana yami ekhona la ekhaya engethembele kuyo. Ineyingane la igcekeni iganiwe. Ithemba lami benginalo kutefa ukuthi ngelinye ilanga ingane yami izophuma kuleya ndawo ekuyona. Ngendlela ebengimbona ekhuluma ngayo nangendlela ebengazi ngayo nami ngoba bengazi ukuthi umzakhulelwa wasiya umbulali kaMeyiwa.
Not far from the Sibia home is the Ntanzi homestead, the family of the youngest of all the accused. 30-year-old Mogane Ntanzi is also referred to as accused number 2. They tell us he has been the breadwinner of their family, providing for 10 people, including his 9-year-old child. Because Mogane was the sole breadwinner, his absence also meant there was no money to even travel to Gauteng, where he is currently incarcerated. They say he got himself a lawyer, as none of them could afford those legal services. All they could do is watch the trial on television, especially on behalf of their mother, who can't bring herself to watch the proceedings. Every time he enters the dock, she leaves the house to get an update later. It was a shock to them when Advocate Malisela Defo dropped the news of his withdrawal.
esathatha naye izinto ngendlela yakhe afuna athathe ngayo ukuze egcine bamele kanti bese sithi mhlawumbe sithembile nje emephethelweni for ukuthi ngwanakho usebatholakele ngendlela engibuka ngayo lo mmeli ubesebenzile ngoba kuzovele konke lokhu nje nokuthi basolwa yilaba abenzi baledwe yilaba kusithemba yena ngendlela besimbone ekhuluma ngakhona nandlela aphenye ngayo kuze sigcine sekuvela ngale ndlela siyambonga nayo ummeli lapha khona ngoba konke lokhu nje kade lokhu sikhuthenisa ngene.
In an unexpected but not surprising turn, Defo wrote to the state informing it that he had resolved issues with what he terms relevant stakeholders and will therefore continue representing accused number 1 to 4. But there's a catch. He has listed a number of demands that he wants adhered to before he and his clients can show up in court on Tuesday. Those include a separation of trial between his clients and accused number 5. He also wants a new judge appointed in the matter and the prosecutor, Advocate Baloyi, removed from the case. Defo says he also wants Police Minister Bheki Cele to be removed from his position and be investigated. In the same statement, he reveals a fresh, new reason why he withdrew from the matter. Without substantiating, Defo accused Judge Maumela of witchcraft, citing it as the main reason why he decided to leave the case. Although at the time of this interview these families did not reveal this information, they agreed that he was subjected to unfair treatment in court. Muzikau Khalelwa and Mogane are said to have made confessions, but according to Advocate Malisela Defo, these were obtained under duress. He claimed his clients were severely assaulted through the use of what he called apartheid tactics to get them to confess. He called on the court to hear a special plea for a trial within a trial. His plea fell flat after Judge Maumela ruled that he failed to follow proper court procedure. Defo had also not filed papers as required for a court application, but addressed the court from the bar instead. To top it all, the state had not submitted these alleged confessions to the court or indicated that they would depend on them. The families believe that their children are innocent.
Umfana lo waboshwa konje kwakumhla kabani mama mhla ka 30 June mhla 30 June mhla 30 May yes waboshwa mhla 30 May inyanga yonke singamazi ukuthi ukuphi kwazothi ngo June angisazi ukuthi kwakumhla kabani bafika naye la ekhaya ma befika naye la uyangitshela ke ngoba bathi angiye kuye ngiyokhuluma naye uthi baba ngiboshiwe ngendlela ebengishaywa ngayo bengibulawa futhi bengitshela bethi bazongibulala njengomnyu khona bambulala eFosrolas amaphoyisa amdubula bathiwa yiba bambulala nami ke bazongibulala bemvalele ehlathini laba bemvalele khona ngendlela ngagcina ngivuma bethi angivumi ukuthi ngabulala Meyiwa kodwa okokuqala babethi akacindezele laba bazomnikeza 100,000 wathi ngalile baba ngoba ngiyazi into engingayivumela engathi ngizothi laba ngibacindezela ngani ngazini ngangikuphi wathi ke bathi bazongifaka icaleni sebengifakile ke ngigcine ngivuma istatement abangibhalise sona ngizivumile angivumi ngoba ngikwenzile ngivume ngoba ngizikela impilo.
Ntanzi's family also claimed that the same happened to their son.
Wathenjiswa 3 million babemshaya before uthe vumele icala umbhaxa nje ufaka nasefrijini sazi efriji bafaka ngoba bemfaka belivulile noma babecimile ngazi-ke la kodwa khona awuthole lo ukuthi wafaka efrijini
afake efrijini yakho pheje
noma ngisanoma bayesejele noma kodwa khona babembombile bona noma bengamfakile esitokisini kodwa babembambile apho babembambe khona.
Sibiya's father says he raised the issue at a magistrate's court where he had been appearing for a different matter and was subsequently moved to a different prison. While the state had not submitted these confessions as evidence or indicated that it would rely on them, it has remained tight-lipped on its strategy to nab the accused. The confessions form part of Defoe's representations to the NDPP in a bid to have the matter withdrawn. For some members of the Meyiwa family, these developments were expected. They believe the 5 men standing trial are innocent. They say a plan is on the cards for this docket if the National Prosecuting Authority decides not to prosecute.
Private prosecution.
Oh, so that's your next step,
Private prosecution.
Meyiwa says his brother's case has been at most marred by corruption.
Leading investigator kwa case 375, 635, 636 yantshontsha statement esasodala ukuthi kuboshwe umuntu wayelapha endlini. Yasitshontsha leso statement ingakho kwavulwa lo case 375. Labantu babawu5 baboshela ukuthi kuzanywa ukuthi babefuna yona ukuthi le case ivalwe kuthiwa ifaka sihlamba bukho noma vele sebethenge nama witnesses boshela abafana abo5 ivale ingabe savela leli bashaya phansi ke manje nali seliveli.
On the 26th of October in 2020, Police Minister Begicele visited the Meyiwa family to update them following the announcement that 5 suspects had been arrested.
Wadidisa umanje. Wadidisa uma wamtshela ngokheli ukuthi ukheli yena. Wabutshela nje ukheli ukuthi yena uzoboshwa nalabantu abawu5 ibona okuyibona suspects. Umuntu okhuluma ngalabo abantu abawu5 vele ngibona nje ukhuluma into engekho. Wayezodlala nje ngoledi ezokhuluma into engekho ngoba into engixakayo sasikhuluma naye uyazi. Ngoba yabo lama investigators at 375 bekade reporter kuyena uminister ucele. Obuthelezi benomakhuba be reporter ku minister ucele bese ukuthi laba abanye be reporter ku Khehla Sithole. In first laba kwakufanele nabo laba ngaba reporter ku Khehla Sithole. Ngezathu zokuthi khona umgebengu obenzakalayo. Kwacaca ukuthi no aba reporter ku minister ngoba lapha into ekhulunywa lapha akuyona le fanele iveze iqiniso cover up yodwa ehlanganiswe lapha. Base ba reporter ku minister uminister besike sikhuluma ngisho naye efonini. Esho ukuthi no uyazi naye ukuthi lento enziwa yilabo abangala ayikho. Nabo abantu abakhuluma into eyona.
So nimbuzile manibona ukheli angavele ecourt ukuthi ukheli kwenzakaleni?
No akaze simbuze. Akasimbuza ngavele ngabona ngayibonela nje the day ekhuluma indaba yokuthi in first ngabona before akhulume leyo nto khona izinto engase ngiyibona. Angifuni ukusho ukuthi yini kodwa khona izinto ayikhuluma ngabothi I know sekhona into influence wrong. Bese ngibona vele ukuthi use cishe mhlawumbe khona into abamsabise ngayo noma khona amacala bawaziwe laba bantu abangala laba bakhe 63 ngoba bagudike lapha ekubophisena abantu nokuthi nje mhlawumbe khona amacala bawaziwe bamsabise ukuthi bazowaveza.
The South African Police Service says it cannot comment on matters that are still in court.
As you are well aware, the case is currently in court and sub judice. Any issues pertaining to the case must be directed to the NPA and the court itself. Evidence will be dealt with in that forum, and as such, the SAPS cannot comment on cases that are in court.
The side of the Meyiwa family that believes that these are the suspects says it has no intentions to comment on the information by Swiso. It says the onus is on the state to prove that the confessions and or admissions made by the accused were made freely and voluntarily without undue influence.
It's said we have spoken to General Khehla Sithole, what is the head of the investigation, who General Ntanzi will update us if anything happens or if there is any breakthrough in the case. So, and today we wake up to the news that the firearm has been found. And we're just hearing it from the media. We've already knew it maybe mhlambe a month ago or 2 months ago ukuthi there was someone who was claiming ukuthi she was when Senzo was shot. We don't know. Only the police lawa asebenzisana no general Sole or Azio. Because you must remember there are two teams in this investigation. There is a team that there are two teams of is supposed to be working together, but they are not working together. So the team, the office in the Chole, they know which is someone who has been claiming which he was there. But we were told that when there's a time for arrest, there will be people who are claiming which they were there. Yes, we all know which there was no one who entered the room. Amaphoyisa njengamanje kumele engabe abopha uLongwethwala for killing uSenzo. Senzo was shot by uLongwethwala. There was no one who entered the house. Bese ebopha all these police who have defeated the ends of justice. Senzo was shot by uLongwethwala. A call was made by Tumelo. The first call when Senzo was shot. What Tumelo, a boyfriend Kazandi, of which he didn't know by name, had shot Senzo, and then a phone was dropped. At the background, Ukeli, she was crying, and that information was given to the SAPS. Why they do not want to arrest Longwethwala, I do not know. For me and my family, it is up to them. It's long overdue. We've said to the police several times, and the good police who are in the side of justice have said it. There was no one who entered the house. Yes, who are working on this case. Even who advocate Chauke in Gauteng, he confirmed it. According to the information that was given to him, there is no one. I had a live recording of Advocate Chauke saying, according to him as an advocate, experienced advocate, there was no one who entered the house.
Important to start off with reflecting exactly that. The family has always had a cry to say that police and investigating authorities never say anything to them. Over the last 6 or 7 years since Senzo was killed, information has been coming to them through the media. And in fact, I remember quite distinctly Meyiwa, Senzo's mother, saying that another issue that they told Begicela about when he went to go visit the family last year is the fact that there were always different police investigators coming to give them information, which they believed was also causing a significant delay in the matter being actually finalized. Now, subsequent to Qele's visit, he was there sometime last year, late last year, around this time actually. In July, Qele had established a special unit that would be looking into this particular matter of Senzo Meyiwa's killing. And of course, you'll remember that Qele came under a lot of fire because he gave deadlines that he never met. He initially said that by Christmas, that was Christmas in 2018, there would be feedback, and that didn't happen. Then he promised by Easter last year in 2019 that there'd be feedback. There was still no feedback. And in actual fact, when Qele had gone last year, it was because Sam Meyiwa, Senzo's father, had also passed away. So he was there to pay his condolences to the Meyiwa family. Now, that's one of the issues. But just like Siyabonga Mia was saying today, Senzo's mother also told us that they know exactly who killed Senzo Meyiwa, and in fact, she was of the belief that the same people who killed Senzo were also responsible for her husband's death. Let's take a listen into what she had said at the time.
Noma ngoba ungaqhamuka azosiza ngani ukube bathi bebulala uSenzo bazoza la ekhaya bathi simbulala uSenzo ubulayo ngephutha bazoza la ekhaya bathi sizoxolisa la ekhaya kubafika eqaleni ngasathi bebulala uSenzo akaze kufike umuntu la ekhaya ezobika ukuthi uSenzo ubulayo ubani abaze bafike kuba bafika isikhathi lokuqala bathi uSenzo ufike ngephutha bese besidadake bakhokhela amaphoyisa abasikhokheli thina babhizi bakhokhela amaphoyisa. iqiniso lilapho nje bakhokhela amaphoyisa wasikhokhela thina babulala uSenzo kuyaziwa khona mangasalala ebusuku abangalala ebusuku hayi kahleni makithi kahleni abafike namhlanje mangibulala bebe ngibulala babulala ingane kaSenzo sife bese beyidleleke imali.
Well, Tami, as you can see, they are very emotional in Ntomfuthi Meyiwa, and one of the biggest cries actually was the fact that the family is not being taken care of, and the fact that she's raising one of Senzo's daughters, who is a teenager in high school, and her biggest cry was that Senzo's killers are out there. She says that these people have money. Now we heard from Siyabonga, he's named Longwe Twala. I mean, that's something that's a name that's been on the rumor mill for the longest time. But the News 24 report, I must actually just reflect this, Tami. The News 24 report says that the weapon that was used to kill Senzo Meyiwa has been linked to a man who's currently serving a jail term sentence in a Johannesburg prison, and that he was also responsible for the killing of an Alexandra taxi boss. So it's very interesting to see whether or not then who else this evidence will be linked to, and whether or not then it will still be linked to Longwe Twala, as the long-standing belief has been that, of course, he is responsible for the death of Senzo. I think for many people, South Africans at large, you know, Orlando Pirates supporters and those who love Senzo Meyiwa, the biggest question has always been, why has it taken the police so long to get to the bottom of this when there were so many witnesses in the house? And you'll even remember that the family reached out to AfriForum to take this matter up prosecutorially. So we know that the police had concluded their investigations, but it was up to the NPA or the likes of AfriForum taking up the matter and investigating it further. So now it seems as though the NPA, according to the News 24 report, is actually going to make a final determination on what to do with this matter. But just to go back to the family, Tami, because it's been 6 or 7 long, painful years, because they believe they know who is responsible. And again, they've emphasized that police haven't been forthcoming with information. Let's hear what the mom said at the time as well.
So it's going to bafike la sikhulumisana ngabe lecala liphelile ngabe mhlawumbe noma lo waboshwa wagwetshwa basinikeze basize siphile siqhubeke nempilo njengabo nje bephila kahle baphila kahle bona thina siphile kahle siyasokola
zinsimbi ngayo nje uyingane ngesiyo lengane yami engiyaziyo noma ngibheka umzimba yathuthumela ngendlela ashayeke ngayo bamshayela ukuthi akavuma ukuthi wayekhona bathi uma ungavuma cindezele umthokozise no Sifiso no bano carrot shuthi bayababala nje uyozuza amadlela alihlaza bamethemba ukuthi bomnikeza imali engango 100,000 bana nje ukuthi sokhokhela imali engango 100,000 nani zoba ufakazi westage athi ngizoba ufakazi westage kanjani ngoba ngangingekho ngiyazi lento club yakhe ayithanda iPirate makudlala iPirate uzobukela iPirate ngoba naye waba buhlungu naye ngoba ufaka Meyiwa engazazi ukuthi kanti kuzothiwa kusasa
ngikhumbulile kakhulu kakhulukazi njengoba singakhona ukuxhumana ngamafoni bayangibuza phela ukuthi ma uphubaba ukukulo omncane usisi omncane ngikhumbulile impela mina njengomakoti wakhe ngiyamthemba futhi nginethemba lokuthi akazayenze le nto leyo ngoba inhliziyo yakhe ngiyayazi.
Ngoba lokhu uthi bethu umzawulahla kusuka umzawulahla umzawukhuleka igama lami engilisho kuye ngoba ngizela insizwa ngimncane ngingedwa kwethu.
Sorry, my lord.
Where is the order which I handed over to you?
Order.
The document you said it can't go from the witness to the court. So, Mr. Balui, you made how many copies?
Enough copies just for
Yeah, but in other words, how many copies did you get? Is it 1 copy or 2 or 3?
We got all the copies back.
No, you're not listening. This witness, how many copies? Let's say, how many pages of the order I said he must give us the information on? How many did he make? When did the copy say how many copies did you make?
There was only one.
One copy.
One sort of order. And then it's just enough for us.
Right. So every council has got that order. And every client has read it. Mr. Mngomezulu, the client read it also.
Not.
This witness says he read it. Fair. Are you saying you saw even number 1 reading it? And number 2?
Was sitting together with him, but I'm not sure if
And number 3?
All
five of them.
One went to the group, my lord, and they looked at it together.
All 5 of them.
Correct.
Can you give all 5 of them copies? Copies so that I just read what the law requires. Mr. Balui, can you give each and every accused that order which was supposed to be made for this court, which has now been publicized?
We will make them copies.
Now give them now. Go to see them getting it.
Well, we only made now. Council will have to make extra copies.
Councillors have got all copies. Mr. Mngomezulu, do you have a copy of that one?
This is the copy.
Do you have a copy?
No, I'm about to receive a copy.
Mr. Mnisi, do you have a copy?
We thought we needed to take them back. Now you can.
No, you have to get copies, all of you. Mr. Numalo, Ms. Micholoro, you all have copies.
Yes, I've just received it.
Yes, my lord, I've also just received it. Thank you.
Yeah, it originally ruled that that order must be expunged. But after having consulted authorities, in terms of our law, there's what we call a posterior ruling statement. And Black's Law Dictionary, the 10th edition, defines it as such. A formal statement endorsed on the trial record. That's what I'm doing. I'm endorsing this order, which I thought it's going to be confidential, on the trial record. Giving an accurate account of the proceedings at the trial, which I hope I've done. A record of what occurred at Nisi Prius after the issue had been joined. The issue was joined on the basis that when this witness, Sergeant Mogane,
Yes, my lord.
was being cross-examined, he repeatedly said he's unable to divulge the information regarding the investigations of the cases which you say accused number 1 or 2 or the others they're involved in, because you would be revealing confidential information. Am I quoting you correctly?
It is correct, my lord.
Yeah, because this court hopes to be fair. There was a dispute as to whether this witness is actually, his testimony is actually the truth or not. And at that stage, this court is not involved enjoining whether this witness is being truthful or not, because he's at the moment giving evidence. This court decided, in the interest of justice, that if it is actually correct that these cold cases he alludes to, including the Ngoma case regarding the murder, the court should make a request in the form of an order that this witness should itemize and categorize those cases in which he says they are cold and they are at the moment not yet finalized, because it was put to him that, for instance, that Ngoma case was finalized, and he said, no, it's not finalized. And by that exigency, this court expected and hoped that this court will get the information which it will share with the accused counsels, that in fact, indeed, such cases are still being investigated. Is that not your evidence, sir?
Indeed. It is correct, my lord.
Consequently, that's why I made that order. And I was of the view that that order paid for the information of this court. And in terms of this posterior principle in our law, I was going to call all the counsels into my chambers and show them the confidential information which was divulged after being extracted by this witness from the various dockets. Because I believe that counsels are officers of this court before they are defenders of their accused. That's a sacrosanct principle of our law. You are officers of this court before you are defenders of the accused, because when you are admitted as counsels of this court, you take an oath to uphold the law practices of this court. So one would have expected that even if counsel informs their clients about the fact that in fact it is correct that there is proof that some of the cases which the gentleman is giving evidence on, saying they are cold, but they have been resuscitated, in fact it is correct that those cases are being attended to. And I believe protocol dictates that not everything which this court divulges by intruding into the Official Secrets Act, and if counsels understand that exigence, you don't have to tell your client about the fact that they say one of the murderers there is Mogane, because you are enjoined to the privity of the information which has been divulged in this court, because this court has made an order that even if it is in terms of the Official Secrets Act that this witness was saying he can't divulge that information, but this court, using its inherent jurisdiction and Section 173 of the Constitution, as Mr. Minister likes saying, it can make use of that information under certain conditions. Okay. So consequently, if anybody wants to use that information, which has been so irregularly been divulged, you are at liberty to do so. And this principle starts from the 15th century. So that the man say, I did judge there is the long term. With the verdict of the jury in the 15th and 16th centuries, the proceedings at Nispri was closed, and the case was sent back to the court at Westminster, from which it was issued for judgment after a statement of the holding of the trial and the verdict that had been added to the record, as I'm doing. This statement, from the fact that it has begun with the Latin word postea, or afterwards, was known as the postea, and was in fact drafted by the party in whose favor the verdict had gone. Whence the phrase postea to the plaintiff or the defendant, which is found in the old reports. You can see in this regard Geoffrey Ratcliffe and Geoffrey Cross, Legal Systems, England, the 6th edition textbook written by Bentley and Hand. It's the 6th edition, if you want to read about this any further, 1977. Okay. Yes, okay, Mr. Miss, I'm sure we can go ahead. to cross-examine.
That's the court visit. My Lord, before I resume with my cross-examination, can I just ask one thing on clarity, my Lord? So it means that on this document, I can read it but not consult, share it with...
No, it has already been shared. You can read it and share it with your clients. That's why I insisted that each of your clients should be given that document, so that it mustn't be said that this information which this court has withheld.
Thank you, ma'am.
You're welcome.
Sergeant Mogane, let's just go back where we paused yesterday. I'll try not to repeat myself, but we'll just wrap up somewhere there and there where I need clarity on those issues.
Para ba no tswela pele mo ile gore le shile gona maobane ge ile gore bona ga ba nyake le gore ba boele go tseding tshadino e fela ge ile gore bona ba tlhoka gore ba kwishishe dilo tse di re ba tlhole tsaka tlo ya kwishishe.
That's the way that everyone put up basic on aspect of all the way. What is in this final typeface?
For the sake of progress, you remember we were talking about the interview that took place at the boardroom.
Yes.
I'll just ask one question in that regard and then move on in that aspect.
I am listening.
The interview that took place between yourself and other members and the suspect was not recorded.
Interview yelong gore lena le bele le gona le ba bangwe ba be leng gore le bele tshana le bona base e recordwe ga se gatishiwe filotso. Correct.
Okay. If I can just take you back, also I just need confirmation. When you firstly approach accused number 2, when you arrested him, you explained to him the allegations in respect of the Nongoma case. Am I correct?
Correct.
Okay. And then when you were charging him, then which allegations did you refer to him?
Can you please explain further? Are you referring to the month of June?
Yeah, the month of June. You have arrested him from his house, and then you explain the allegations in respect of Nongoma case. Correct?
It is correct.
Yes, and then you took him to the station.
La Misha's police. That is correct.
Wherein he was charged and detained.
That is correct.
Yes, at that time, when you charged and detained him, which allegations did you explain to him? Was it in respect of Nongoma case or in respect of this case, Foster's case 636?
We informed him about the Nongoma case.
So, then on the following day, when you booked him out, you then interrogated him on the Foster's case 636 and not Nongoma case.
We firstly interrogated him on the Nongoma case and then followed up with the Foster's case.
And then in respect of this phosphorus case 636, the accused number 2 denied any involvement in this case. Am I correct?
Molatofatso wa bobedi ka molato wa phosphorus 636 yena o ile a ganela gore ga senke ya ka karolo ya molato ke nnete. It is correct.
And then, in respect of the Nongoma case, if I remember very well, your response yesterday, he was never taken to court for his first appearance at all.
Kamolatola wa Nongoma ge ba gopola botlhatsi ba lena ba maobane lena le rile ga senke a ishiwa kgorong.
Hello, Pichaga Boji. We are Mishi Horong, who may fit a horong, Chuchisarlo, Kaurvel, Nongoma, as it is in Yaga. The Labari Mishagaya for Soras.
If you would recall properly, we took him to court and the prosecutor said, this Nongoma case, it's not under their jurisdiction. And that's when we had taken him for the phosphorus case.
Yeah.
Must very true, which is sometimes it's a so good. I what are the most of the
Yes, but in essence, he was never taken to Nongoma court for his first appearance or for his appearance under that case. After the prosecutor has said that it does not have jurisdiction over Nongoma case.
Kamra gore motšhotšhisi a re yena yela ya Nongoma ga e ka fase ga jurisdiction ya gagwe mo e leng gore yena a senke a tswelele pele ga kgorotsheko ye e rileng ka molatola wa Nongoma. It is correct.
Okay. So it means, Sergeant Mogane, on the 19th, I suppose we are on the same page that you saw the prosecutor on the 19th of June.
Le a dumela gore le bone motšhotšhisi ka di 19 tša June. That is correct.
So it means on the 19th of June, when the accused was not taken for his first appearance, the 48-hour rule expired in respect of Nongoma case, since he was never taken to Nongoma court for his first appearance in that case.
Ora gore jwalo ka ga lena le bone motšhotšhisi ka di 19 ke ge ile gore ge molatofatso wa basare yena a tsena ka kgorotshekelo ke mo e leng gore di hour tšela tše masomenne seswai bese tše di expirile ka molatong wola wa Nongoma.
Anje joba yeni amisanga yakatwa nitsalana ushuthilela mahora amashumamane shakadombi ushutha seqile mayelana nitsalana Nongoma.
No, we saw expired.
No, the 48 hours had not yet expired.
Okay. It's fine, I'll leave it for argument. Let's continue. You then, on the same day, on the 19th, when accused was not taken to Nongoma court for his appearance, in Phosphorus, his case was not enrolled, and he was supposed to be released. Am I correct?
Jwalo ka ga lena le re ka di 19 tšhekong yela ya Nongoma ga se a ye na go yona gora gore yela ya Phosphorus o be swanetše molatola wa gagwe o tšhollwe o jwalo. That is correct.
And he was not released. Am I correct? According to the exhibit that we have read into this court.
And
a further detention after there was an endorsement that the accused must be released was unlawful because you did not have any warrant of arrest to arrest the accused on any other further or subsequent cases that you were investigating.
Se se bolelang gore lena le tswele pele le moswere besche go le ka ntle ga molao ka lebaka la gore le be le sena tokomane ye be le dumella gore lena le be le ka moswara go ba le ka motswallela nako e nngwe e fetang eo.
No, but it's again but it's not a J50.
It was not unlawful, however, we did not have the J50.
Thank you for Yes, at that time when you did not have a J50, authorizing you to detain accused number 2 further after his matter had not been enrolled in forced arrest. You took him further for further investigation. Am I correct?
Jwalo ka ga le be le sena yona J50 yela lena molatofatswa le ile la motia le ge ile gore le be le sena tokelo ya gore lena le ka moswarella lena la motia le ile motisha dipotšišo le ile nyakishisha. It is correct.
Okay.
And am I correct to say after Foster's court, when he was detained around 1339, you recall me if I'm quoting the time wrong, it was 1339. From 1339 up to the time when he was detained at Pukeng police station, you had no warrant of arrest in your possession to keep the accused in your possession.
Lena go tlogelle nako yela ba re le tla ba phošolla ge le gore nako ga se ba e be gabotse nako yela ya 1339 fela le be le ile mo tswallela ka kwa ka police station ya Phutheng ra gore lena le be le sena tokelo tša gore le be le ka moswaro.
Okay. If I also recall your examination in chief, the reason for you to take accused number 2 to his house is because you wanted to check the hoodie that he was wearing. When the incident in the forced arrest case 636 took place.
Mo be leng gore molato wa forced arrest case 636 o be o dira re tswa. I do not understand. Can you please rephrase so that I will be able to understand correctly?
Okay, thank you. I'll repeat. And if I'm correct from what you said, your evidence before this court, that the main reason you did not release the accused from forced arrest court and proceeded to his house because it was because you wanted to go and search for the hoodie which was worn by the suspect on the date when the incident took place under case forced arrest 636, which we are dealing with in this matter.
Le rile le baka le dirileng gore lena le ska tala molokolo ke ka lebaka la gore lena le be le nyaka go misha ntlong mo be a dula gona gore le ilo lebella hoodie ba ke fa yela ye leng gore ba ere ka tšatši le be go diragala molato wa forced arrest case 636 ye re bolelang ka yona ya
Kusho ukuthi isizathu sokuthi ngingamekhulule emva kwase-forced arrest ukuthi nanifuna ukuya endlini yakhe ukuthi niyohlola ukuthi ngayithola le hoodie yayigqokwe sola kuleli cala lase-forced arrest 636 kunjani?
Yes, as we were still gathering evidence for the case 636, it is correct.
Is it also your evidence that in 6 years' time, from 2014, 15, 16, 17, 18, 19, 20, 6 years later, you proceeded to accuse number 2's house with an intention to search and seize when you did not have a warrant, a search warrant in your possession in respect of the case or in respect of the information that you wanted to search and seize?
Mo mengwageng e e tshela le bentse le nyaka go ilo tswella pele le ilo lebella le ilo tlhola kwa ga gabo ba mo bea dula gona le ge e le gore lena le be le sena dipampiri e leng gore di be di dumella gore le ka e le ilo sesha
mhlawumbe kweminyaka eyisithupha nasika nemzina kamsolo speed ukuthi niyohlola noma nikwenza uphenyo noma ukuyosesha ningenayo i-warrant nalezi kuthola lapha kuyani
Re le ka gopola botse molato a so thome ke rena mathomo for 2014.
If you would remember properly, this matter, we are not the first investigators since 2014.
angakhumbula kahle thina ukuqala ukuthi siphendule lucala kusukela ngo-2014.
Go fitile masong a mantši kudu fitlhela rena ba re fa ona.
There are many investigating officers that has worked on this case until it was brought to our attention.
baningi abaphenge leli cala lapho izolethwa kwe-ET.
Rena ro hweritše molato ka December 2019.
We got this matter in December 2019.
Thina satholetha December 2019.
Thank you for that explanation. But I don't have a problem with how many members who have investigated this case. That's not my question. That's not where I'm going to. Whether you were the 15th or the 30th member to investigate this case. But on the 19th of June, when you went to search in accused number 2's house, you were not in possession. You did not have a search warrant authorizing you to go and search the item that was worn by accused 6 years back. That's my question.
le gore le ba botse gore ba sena ba mathomo ba go bereka go molato o eupia selo se ba se bolelang ba re ka di 19 kgweding ela ya botshela lena le be le sena ditokomane tse leng gore di be di dumella gore le ka sepela di ilo nyakishisha ka mola ntlong ntho e leng gore molatofatša o be a ya pere mengwaga ye tshela e fetileng
kuzothi kushuthi ngitshana 19 kuJune ane ayiphethe warranty ukuthi niyosesha lapha endlini yakusola ufuna lezi kuthiwa zazigqoke sola iminyaka esithupha eyadlula.
Go na le molaotsoko ka mogare ga Criminal Procedure Act o re dumelelago go swara ebile le go searcha re sena warrant ebile gore a ke sa gopola ke tla ile go lebelela gona gore molaotsoko.
There is a certain law in the Criminal Procedure Act, even though I would not recall which section refers to that. However, I will go and search for it, which allows us to arrest and search a place even without a warrant of arrest.
Yeah, no,
or a search warrant.
ukuthi singasosesha nanoma singenayo i-warrant sazofuna lo mthetho kuphela. Ikhona lo mthetho.
No, thank you for that. Don't worry about that law. We'll argue about it before this court. The only confirmation that I want to get from you is whether did you have a search warrant or not.
Ba re le ska tshwenyega ka molato o bona ba tla o lebella gape ba tla ba boleishana ka ona gona mo foro. We did not have a search warrant.
That's all I wanted.
Singenayo i-search warrant.
That's all I wanted. And then you entered accused number 2's house and you searched and recovered the ammunition, the bullets, if I'm not mistaken. Am I correct?
Le ile la tsena ntlong ya molatofatšwa wa bobedi la tlola gana ka molala kumana ikolo.
Ngena lapha Ntanzi speed nasesha ngena nithole iinhlanzi sibani.
It is correct.
It is correct. Kunjalo.
And also, you did not have the search warrant regarding any bullet or any firearm that you were looking for.
Le bentse le sena yona tokomane ela ya gore le search le be le ile kumana tsona dikolo tse.
Ngenayo imvume ukuthi niyofuna iinhlanzi sibani.
It is correct, so.
Okay. Thank you. Let's go back a little bit on the occurrence book. Since we have testified, maybe you can refer if you want, but I will remind you
ba re tlo boela morago go occurrence book ge ile gore lena le a nyaka le ka ya go yona fela ba tla le go botša.
Accused number 2 denied any involvement in respect of phosphorus case 636 when you interviewed him in the boardroom on the 17th of June 2020.
Molatefatšo wa bobedi yena o ile a gana gore e be ile karolo ya molato wa phosphorus case 636 ka di 17 tša June 2020.
So the speed wa pe kuti yana ga le bitara le 636 ko so da in caso de meeting ne ga ma ke board room man books.
It is correct.
That was the first and genuine response given by accused number 2 when he was asked about this matter of phosphorus case 636.
E be ile karabo ya gage ya mathomo ya nnete ge be le motiša ka molato wa phosphorus 636.
Wako upendulo yakhe yokuqala upendulo manje mbuzo ngale tsale 636.
Re ya nnete le ra yanga re tshwate go le phetulo ya mathomo ya nnete a kusho le ya nnete ra ya.
What do you mean when you are saying the first genuine response from him? Because we were expecting the first answer from him.
Let's move on. Let's move on. On the 18th of June, he was then booked out for the whole day on the 18th of June. You remember? At 8:15 as per serial number 520. That's the exhibit entry that you have read into this court. He was booked out at 8:15 and only detained at 2:30 in the morning.
Le motere ka 8:15 yena a bušwa ka 2:30 e leng 2:30 ya matsha go ya ka I do not have it, however I do remember it.
Ka 18 June wa ke shwa go 8:15 uyange ngada umbhalo lo bhalo to 522 plus so 2 exe. Yes.
And then on the same day, on the 19th of June, at 2:35, the suspect was charged. You remember? That one.
The 19th of June, at 2:35, yes, I do recall.
2:35,
and early in the hours of the same day, 19 June at 4:50, the suspect is booked out to Fort Dora's court.
Ya go gore ka masa ka tsone di 19 June ka 4:15 ya masa ke mo e leng gore molatefatšo wa tšewa o išwa kgorotshekelo ya phosphorus.
4:15 ngale le langa umsolo wakhe shayisa inkundleni yamacala yasephosphorus.
It is correct.
And according to your examination in chief, when you were on your way after you had booked out accused number 2, you were called by Colonel Gininda, who told you that accused number 2 wanted to make a statement. Am I correct?
Sakubona ukuthi ke nathi sendleleni nathola ukuthi ngivela ku Colonel Gininda ethi ke umsola ufuna ukuyobhalisa ke statement esithize.
That's not the evidence I listened to. They got a message from Gininda to say no longer go to the court.
Yes.
Go to Morocco because I have now located a person who can take a confession. After Gininda had told them the previous day, told accused number 2, if the evidence of the sergeant is correct, that you don't have to make a confession or a statement before me. I'll find somebody. Confession. Okay, that's the evidence.
Yes, ma'am. So they
Not
will
that
not
Pineda told them on the way to say the suspect wants to make a confession. No.
Okay.
He had
But-
already said that the previous day.
My lord, but the call was made in the morning when they were on their way to Phosphorus Port
To say what?
to say that the accused must be taken to make a statement.
Yes.
Yes.
Not that he wants to make a statement. Because the arrangements were already made by Tininda, in other words.
Thank you, my lord.
Yes.
Can I just proceed, my lord?
Yes, we proceed.
The line of my questioning, because I'm now getting distracted.
You are not, Ms. Msololo. I'm quoting the correct record, what it says. You can ask Mr. Mngomezulu, am I confusing anything?
No, my lord, this
Hello?
is the correct.
Ms. Msololo was not there. I'm quoting the correct evidence. Now I'm being told I'm distracting.
Thank you, my lord.
Please.
My lord, can I proceed? My question is, why now, when the accused has been booked out from 8 o'clock up to 2:30, when he was booked back, now that he has changed his mind?
Yes, my lord. I don't know why counsel says the accused has changed his mind. The court is just now to counsel what the correct version is, that the incident started already the previous day on the 18th when the Carltonville, where he intimated that he want to make a statement, and Brigadier Gininda then said he made arrangements. And on the 19th, he contacted the witness to say he has made arrangements. There's no change of mind.
Can I rephrase that question, my lord? Is it correct that the accused only indicated that he wanted to make the statement during the time when he was booked out for long hours, from 8:15 up to 2:30 in the morning, when he indicated that he wanted to make a statement?
Afake nnete gore molatofatšwa yena o rile go nyaka go dira statement nako ela ge ne ba mo tšere nako e telele o tlogeleleng ka 8:15 go fitlhelela ka 2:30 ke mo e leng gore o ile a re o nyaka go dira statement.
Once again, I don't know whether the part that says when he was booked out for long hours is correct or not, because the witness said it was around 4:30. So it was from 8:15 to 4:30 when he signaled his intention, when he made certain admissions, Lord, and arrangements were then made. I think the addition of long hours will not be.
Thank you, my lord. I'll leave it for argument, my lord. Can we just move on? The hours are indicated from the OB entries, my lord. Let's move on, Sergeant Mogane.
Taba ela ya di-iri tše di telele ba tla e lesa ba tla e share ka bona ka bona ga ne jwale re tswela pele.
Is it also your evidence that when you were with accused number 2 in hospital or outside hospital, he was also asked about the involvement in the case of Phosphorus case 636?
Ke tlatse ba lena na gore molatofatšwa e rile ge be re na le yena ka ntle ga sepetlele.
On the 18th of June, when you booked him out and went to hospital or his place of employment?
Ka di 18 tša June ge be le mo putlile out le ile sepetlele goba mo be a šoma gona. It is not the hospital, it is where he was working.
Where he was working. Thank you. And where he was working in hospital, you also had interview with the suspects.
Mo be a bereka gona le ile la kgona go boledišana gape le yena le ba le interview.
Rapele or re šetše re feditše ka go checka go lebela gore ba se go mmerekong.
Are you saying before or after we had checked that was he at work or not?
No, at that time. At that time.
lapha kuyankampani noma secretary ukwenza lokhu kuhlaluthe khona noma ngekho emsebenzini?
At that time, I don't know according to your evidence, it can be before, it can be after, I don't know, but you were at his work employment at that time when you interviewed him.
Bara ga ba tsebe gore be le ka pele go ba besitse le ka morago fela ge be le mo yena mona mo be a shuma gona.
Awazi ukuthi ungaphambili noma ungemuva ukuthi iqesho umsebenzi wenza license khona kodwa khona indoda abanayo khona ngaleso sikhathi ni license khona.
Ke go pala gore ke rile Brigadier Gininda o re joinile le Sergeant Mogola.
But I remember it's that I said Brigadier Gininda joined us with Sergeant Mogola.
Mangubulayo ngasho ukuthi uBrigadier Gininda kweza wazohlangana nathi no Sergeant Mogola.
Yes, and they got
Re la ba emetse mo gating ka ntle ga mine.
And we were waiting for them at the gate outside the mine.
So swanide esangweni ngaphandle kwemine.
Omme re Brigadier Gininda fitla le Sergeant Mogola ka introduce go Brigadier Gininda ra wa ke Ntanzi, no?
And when Brigadier Gininda came with Sergeant Mogola, I introduced him to the Brigadier that this was Sandiswa Ntanzi.
Wathi kumefika lo Brigadier no Sergeant Mogola aseke ngethula ngithi uyena ke lona uSandiswa Ntanzi ngethula ku Brigadier Gininda.
Pela mo tsara ba re tlile go tlo re fa gore ka nnete go lo mshomong na ka ge ke modi tsa Brigadier.
And Brigadier said we are here to make sure whether were you indeed at work, as I had explained to the Brigadier.
Athi ke hayi ke uyakuchaza ukuthi asidana nje uzothola isiqiniseko sokuthi ke ngempela ukhona yini emsebenzini njengoba kuchaza
That is the conversation that we had before we went into the mine.
Okay, in other words, at no stage wherein the accused was asked about his involvement in this case at that time.
Kana boye ga gona mo eleng gore fa tswa o ile a botšiwa ka kamano ya gagwe go molato.
Ukuthi lapho akukho la umsola wabizwa khona ukuthi uthengiteka kanjani kuleli thala.
No, Brigadier lo ya motšisha after amu muriche ditokelo tsa.
Brigadier asked him after he explained his rights to him.
Brigadier wamtshela emva ukuthi wambuza emva ukuthi imphazaneke.
And were you present?
Yes, I was.
Okay. Did the accused respond?
He remained silent.
And then on the 19th, early in the morning, when you had received a call that an accused person must be taken to Lieutenant Colonel Rapadu, did you take him to any police station? According to your evidence?
Lieutenant Rapadu,
Police station.
Yes, we took him to Moroka police station.
Okay. Am I correct, Sergeant Mogane, to say from the appearances as they appear that he was booked in the early in the hours? It means the suspect on that day he did not sleep.
Jwalo ka ga ile gore yena o ile a o ngwetswe gore o fitlhitswe mo gare ga masa ra gore molatofatso a se ya rona.
Ngendlela obonakala ngayo ke uthi wakhishwa ngasikhathini bona sengathi umsola azange athole ithuba lokulala kunjani?
Ke agana ka roba robetse kolong ya ranger tsa mali.
I dispute that as he was sleeping in the vehicle as we were driving.
Okay. But he was not put into the police cells where he was allowed to sleep.
efela ga se a tsentswe ka diseleng mo a ile ba dumellwa gore a robale.
That's a good question, my lord. What is the basis for counsel to say that the accused was not put in a cell and allowed to sleep?
My lord, I'm seeking clarity from the witness looking at the time when he was booked out, my lord, from the cells and the time when he was booked back in the early hours. That's why I'm just getting clarity from the witness. Maybe he was allowed to sleep. That's why I'm just getting clarity from the witness regarding that.
As I understand the evidence, these witnesses, they were from Mogane, am I correct?
That 18.
Or Sibanye, whatever.
Okay.
Okay, fine.
I do not recall.
Okay, yeah, continue with your questions.
Thank you, Minister. You can't answer, you can't recall, or you remain with your answer to say he slept in the vehicle when you were traveling.
There is a point where we took him back to the cell and he slept a bit, even though I do not recall how long. Did he sleep.
Oh, okay. I can refresh your memory because I have recorded the entries. From Mogane, he was booked out 8:15 in the morning and he was only booked in at 2:30 on the 19th of June. And then he was charged. He was charged
15 of 2:30 yamas.
Yes. And then he was booked out at 4:50 after that entry.
And she was 4:50 kamera It is correct.
Can you recall anything or you can't recall?
I recall that we had placed him in the cells when we came back. And we took him out of the cells when we left again.
Yes. So if I understand what you are saying, so you would have booked him, you would have put him into the cells after 2:30. And he was taken out at 4:50.
La muncha ka metsotso e lesome ka pele ga iri ya botlhano. That is correct.
So in other words, it means that he was only detained for 2 hours. He was only put into the police cells for 2 hours.
Se se bolelang gore o tsentshitswe ka diseleng iri tse pedi fela.
Okay. And he made the statement.
It's actually not 2 hours. We don't want to be pedantic, but it's more than 2 hours. 2.5 hours minimum to 2:25.
Minus the witness can correct that. The witness is the one who knows better. If I'm not giving the correct estimate, you know how long was the suspect put into the cell.
3 hours and 2.5 hours.
The time could be between 2 hours and 3 hours.
From my calculations, from 2:35 to 4:40, it gives me 2 hours, 20 minutes.
Go ya ka yena ge a se dira di calculation go tlogela ka 2:35 go ya go 4:50 e monea di iri tse pedi le metsotso e masome a mabedi.
We waited for one like
You have said it correctly. So,
Thank you. And it is your evidence that when he was taken to make the statement, sorry, my lord, not that it, can I rephrase, not that it is your evidence. Am I correct to say that when accused number 2 was taken to Lieutenant Colonel Ropadu, he had not slept, he had only been kept in the police cells for 2 hours, 20 minutes.
ke nnete gore molatofatšwa ge be a išwa go lephodisa Raphatu yena ga se a robale o loketse fela ka diseleng di re tše pedi le metsotswana.
Ngabe kuninginiseni mangithi-ke umsola soyalithatha ngena ngaso emaseleni nokuthi athathwe kayise esikhishwe siyiswa ku-Lieutenant Raphatu. Wayiswa nje wayehlala nje imizuzu amahora amabili nemizuzu.
nka se ra robala ka gore ge ba iša diseleng ba išwa ke maphodisa mo police station eo.
I cannot say he did not sleep because when they are taken to the cells, they are taken by the police officers from that police station.
Angeke ngisho ukuthi wayengalala ngoba uyiswa emaseleni bangiswa amaphoyisa lapho kuleso station.
Okay.
So I don't want to interfere, okay? You see the defense that was put by Mr. Mngomezulu is that this witness, accused number 2, was never taken to Raphatu. He was taken somewhere to be assaulted, choked, etc., etc., etc. Inanda comes there, opens the boot of the car, gives him documents, sign here, sign there, sign there. Assaulted again, then they realize, oh, something has not been signed. Then they take him to Morocco now. And when they get there, are you with me?
Yes, my lord.
These versions, I want to be fair to you, Mr. Mngomezulu, and you. They are mutually destructive. Because the way you are putting it appears as if you are not disputing the evidence of this witness. When in fact, according to Mr. Mngomezulu, he never ever took Mr. Ntanzi to Raphatu. He met somewhere, the hospital, etc., etc. Keys were given, blah, blah, blah. Taken to an open space, assaulted. I'm just saying it.
Thank you, my lord. I was just referring the witness as to how the incident unfolded during the time when he was booked out up to the time when he was booked back in the early hours.
Okay, no problem.
Yes. I have not touched the issue of the accused and the Lieutenant Colonel Raphatu. I'm just talking about the night preceding to that incident, man. I did not get the answer.
It's a Garawayal Nabi.
Kana le rileng hapa gare
By the way, what was your question as you have distracted me? May you please repeat the question?
No, I had said it means for the whole night the accused had not slept. If he had slept, he only slept for 2 hours that he was put in the cells.
Bona ba rile gora gore bosego ka moka molatofatšwa ga se a robale ge e le gore o robetse yena gora gore o robetse di iri tše pedi fela.
Ukuthi angisho ukuthi umsola angalali ebusuku. Uma uthiwa kwasi ulalala amahora amabili kuphela.
a robetša ra go robetša nako eo ka ya 2 hours and 40 minutes 20 minutes.
Slept, meaning he slept that 2 hours and 20 minutes that you have referred to.
Wayalala ulala yona nama-hours ukhuluma ngawo amabili.
And then on the 22nd of June 2020, when the accused was taken to court, he was taken not for Nongoma case. Am I correct?
Ra gore ka di 22 tša June molatofatšwa ga se a išiwa go tlatshekelo yena o ba sa išetšwe molatola wa Nongoma.
Which he was detained.
22 June umsola umeseyiswa enkantolo wangeselwa lelitala kaNongoma.
O be a tswaleletswe wona.
Ale ayiboshelelwa.
La o išetšwe for Mogane.
He was taken for cocaine.
Ayisola ilitala lasePhukeni.
from the evidence of Jonathan, Mr. Buthelezi, and Mr. Buthelezi, they testified that they were asked by yourself on respective dates when accused number 1 was taken to make a statement to Lieutenant Rapadu, and when accused number 1 was taken to make a statement to the magistrate, Ms. Cronje. Their evidence is that they were requested by yourself to escort you as you were traveling.
Jonathan Buthelezi.
Sorry, accused 2, my lord, not accused number 1.
Jonathan Buthelezi, bona ba boletse botlhatsi ba gore ba boditswe ke lena gore ba sepele le lena ge be a ilo dira statement sela go magistrata e leng gore molatofatšwa wa bobedi e leng Ntanzi o be a ilo dira confession e wa go statement seo.
Ukuthi ufakazi obuvela kuJonathan nobuvela kuThelezi ukuthi umsolwa wayesofuna phakathi isa statement futhi wayesofuna ukuthi magistrate ukuthi ayobhalisa statement nokuthi ke nina wena waphathela ukuthi bazoniphelezela.
Ke tlhalosetse gore ka tsela e.
May I explain it to the court in this way?
Ekurhuleni Metro Police Department khopetšwe ke Brigadier Gininda le di supervisor tša Ekurhuleni mo Metro Police Department go thuša re go sepediša di suspect tša rena ka bona molato.
The Ekurhuleni Metro Police Department was requested by Colonel Gininda and the supervisors to accompany us as we were traveling with the suspects in this matter.
Okay, in other words, you are saying you were never involved in the request that was made requesting the members to give escort to yourselves.
Kamanju amang lena le re ga senke le be karolo ya kgopelo ye we ya gore le kgopelo gore batho ba utlwe batho se fela le le.
Ka ge šetše ba ba file tumelo la go šomišana le rena.
As they had already given them the right to work with us.
Ba ba re fa tumelo la gore rena re be re ka mo fase mo re kana ra founelana ge go na le mšomo tshwantse re o dire.
And they gave us the right to contact each other if there was any duties that we were supposed to do as we were working on the ground.
Okay, so as you had been given a right to communicate, were you given specific members to request from the metro each and every time when you needed their services?
Correct, we were given that particular group.
In respect of accused number 1, in Albertine on the 30th of May, were you also present? In Albertine,
May, where the mulatifatwa wa mathomo.
On the 4th of June. On the 4th of June.
Barakadi for June.
Actually, the 5th of June.
Yes, it is correct.
who arrived first at the Alberton station between yourself and Jonathan and his crew?
Go fitlhe mang pele magareng ga lena le Jonathan le setlhopha sa gagwe ba sepodising sa Alberton.
a ke sa gopola botse re fitlhela mampela a ke sa gopola botse mara bona ba fitlhile re rona fitlhile.
I do not recall who arrived first, however they arrived and we also arrived.
Okay, do you recall as to where were they waiting, Jonathan and his team?
Jonathan le setlhopha sa gagwe ba eme kae? Yes, I do recall.
Where?
Police station.
Outside the police station.
Thank you, my Lord Medical. Just bear with me. Thank you, my Lord. I've got no further questions.
Okay. Yes, Mr. Oh, you said you were waiting. Mr. Baloyi, any re-examination?
We were asked by counsel for accused number 1 and 2 regarding the appearances of the accused in Boksburg.
Botsitswe ke ramolao wa molatofatso wa mathomo lwa bobedi ka go tswelela nga Boksburg.
This is not as far as exhibit E is concerned.
But we are exhibit E.
Yes, exhibit E. On the 27th of October.
That the 27th October.
2020. As to whether you had permission from the station commissioner to postpone accused number 2 to the area police cells.
Or lena level filwe tikelo ke station commander or leka molatofatswa wa bobedi yena le ka misha selenja dileria. That is correct.
Yesterday we handed the original of the exhibit EP.
Maobane re fane ka tokomane yela ya EE.
I just want to draw your attention to a letter my lord, the letter which appear right almost in the middle of the proceedings. If you can just place the contents of the letter on record.
Bar banyaka gore le go lengwalo le le bale le ba le godimo le kgona go kwa gape.
Era ukuthi ngifundele encwadi, ngifundele enkantolo.
Lengwetše gore the station commander South African Police Service Valeria
Ukuthi station commander station sase-Valeria.
mo godimo ngwetše inquiries Colonel Toka.
Bale lapha ngenza ukuthi inquiries.
On top it's written inquiries Colonel Toka.
Gomme ba e addressitše the magistrate senior public prosecutor Boksburg Magistrates Court Boksburg.
And it was addressed to the magistrate senior public prosecutor in Boksburg Magistrate Court.
Gomme yone ngwala ka tsela permission to place a suspect at Valeria police cells.
And it reads as follows. Permission to place suspect at Valeria police cells.
Here, point number 1. Here with permission to place under mentioned suspect at Valeria SAP cells for further detention.
When number 1 is read as follows. Here with permission to place under mentioned suspect at Valeria SAPS cells for further detention.
Omega Mama Shakaning English case number 636 of 10/2014.
And in the box is written case number 636/10 of 2014.
Umel Shakana la latela lengwetše gore name of a suspect Bongani Ntanzi.
Second block it's written name of the suspect Bongani Ntanzi.
Shakana la mafelelo ngwetše Colonel B.N. Gininda.
The last block is written Colonel Investigative Officer Colonel B.N. Gininda.
Point the permission is granted by Colonel Toka SAPS Valeria.
Second point, it's written permission is granted by Colonel Toka SAPS Valeria.
Mofase assign English Station Commander Colonel SAPS Valeria MS Toka.
And underneath the sign is also written Colonel Station Commander SAPS Valeria MS Toka.
Mofase amala date 2020 10/27.
Underneath it's written a date 2020 10/27.
October 2010.
A copy a certify again na PV Mogane custom beside clerk of the court of Boksburg police station.
And a copy
Boksburg court.
A copy was certified by myself, Mr. Mogane, with the stamp of the clerk of the court. That is all.
You were also asked by counsel for accused number 1 and 2 as to how you know Mr. Mchiako.
Ilela butishwa gape gore Mr. Mchiako yena le motsebi wa butishwa ka ke mmele wa molato fatso wa mathumolo wa bo.
And you then gave an explanation. Can I once again ask you to turn to the transcribed version of Exhibit EE on the 27th of October?
ye leng gore e typilwe ya 27 October yona ye ya EE
Manje singabakala
ka tlhaloso
ila ukhombisa khona ukuthi kwakuqobe ukhohle phansi.
Ngiyabona.
Yes, I can see.
Who appeared for case number 2?
Imang obe ile umleleli wa mfundisi.
Ubani owayemele umsolo wesibili?
Ingwetshe gore Mr. Ntokozo Mijiyako Attorneys.
It is written Mr. Ntokozo Mijiyako Attorneys.
Right, lapha ke umthokozo Mjiyako owasefemile labamili labamjiyako.
The case was then postponed to the 27th of November, 2020.
Molato o ile wa hlekshetswa morago go issuwa go di 27 November 2020.
Leli tsala ke lesepetsele ngomhla 27 November 2020.
On the second page.
Mo page ya latela.
It
is correct, I confirm.
Who appeared for case number 2?
Imang obe I am chimula kufatwa go bedi.
Ubani ke owayemele umsolo wesibili?
This language, Mr. Mijiyako gape.
It is still written Mr. Mijiyako.
Thank you.
Are you through with that letter, Mr.?
There's a formal letter that is on record. If I can just ask you to put that contents thereof on record.
Khona ke incwadi ke engifisa ukuthi uyifunde ukuze iqoqe phansi.
Mo mengwalo ngeme golo godimo ga letlakala engwetse Mijiyako Attorneys Incorporation.
In bold, on top it is written Mijiyako Attorneys Incorporation.
Ngamagama ke amakhulu ubhale lapha phezulu ukuthi abameli bakwamjiyako.
Alatala mengwalo ring the Director of Public Prosecutions, attention Advocate Jibaloi, per email on Ngasibali.
Then it is written the Director of Public Prosecutions, attention Advocate G. Baloi, and an email address. And the witness says he would not state the email address. The date.
Advocate G. Baloi.
3 March 2021.
It is dated the 3rd of March 2021.
Whenever like I say, like, dear says.
It is written as follows. Dear says.
Malagapega mengwale mekutunyana RE/Ntanzi for Floras Care 636 of 10/2014.
Also written in bold RES/Ntanzi for Floras Care 636 10 of 2014.
Ubhaleke lapho ukuthi sihloko sithi Ntanzi icala lasePhosphorus 636 10 of 2014.
Point number 1, we confirm that we act on behalf of Mr. Vongani Sandison Ntanzi, who is accused number 2 in the above matter.
Number 1 is read as follows as the witness has just read it, my lord.
Immediately after the last court appearance, Mr. Ntanzi withdrew a mandate as his attorneys of record and opted to be represented by the Legal Aid Board.
That is the second point, my lord.
We also not been receiving financial instructions from Mr. Ntanzi. Point number 4, yet Mr. D.N. Mngomezulu, who has previously appeared on behalf of Mr. Ntanzi, is no longer with our firm and has joined the Cape Bar as a people advocate.
And futhi wabhala ngephuzu lesine ukuthi uBM Jabu owayemele sola ngalela usashiya kuleyo firm leyo uyasuka wayesebenzela eKP.
Yabuhlani yona, I am mindful of our duty to formally inform the court about these developments and to withdraw as Mr. Ntanzi's attorneys of record.
Nje wasecela ukuthi ayifisa ukuthi inkantolo yazi ngalokho ukuthi ke sebeshiye phansi uba abameli kukaBabaNtanzi.
However, due to a family bereavement, I am unable to make it to court on Friday, 5 March 2021, and my colleagues are out of the province.
Ufuthi ke ngeshwa ke ifana usivelele ngakwazi ukuthi ngomhla 5 March yo vela enkantolo ukuthi ngiyosithatha uba kodwa ke futhi ke okunye ukuthi abekho abanye ngisebenzisana nabo.
Point number 6, may I therefore humbly request assistance in informing the court on our behalf about this development and to request that our non-appearance be excused and our withdrawal of attorneys of record be confirmed.
Ngicela kwasisi inkantolo ngalokho futhi ngifuna ukuthi ngicele inkantolo ukuthi sesishiya phansi njengomeli so.
Point number 7, thank you in advance for your kind assistance herein. Yours sincerely, Mngomezulu Attorneys Incorporation, DL Chia.
Thank you. It was put.
No. Put in the practice number. Remember the allegations.
Yes.
Subtle allegations that the gentleman is a fly-by-night counsel or attorney.
Let's just put the practice
So
number.
put the
practice number.
legal practice number.
Mofasi Inuichi, legal practice counsel number.
It is written, legal practice number.
18209.
Manje la kufanele inombolo yabo yokugunyaza ukusebenza njengabameli ithi 18209.
CIPC reg number.
Alokuthi CIPC reg number
2017 stroke.
2017 stroke
149
229
stroke 21.
Stroke 21.
Omegamo Inuichi vet number.
And it is also written the number.
Vet number
451028.
451028.
4914.
4914.
Barbara Lebuha.
Mr. Baloi, put the address of this attorney on records because I see it here.
Barbara Lekabala. Le address.
But we don't know whether he had an office or not. When the evidence was unfolding, it doesn't exist, apparently.
The address is right as follows.
10 8th Street, Melville, Johannesburg.
10 8th Street, Melville, Johannesburg.
Phone number.
Should I read the phone
code?
number?
Yeah, the code.
Our code is 2109.
2109.
Telephone number plus 2711
plus 2711
482 2325.
2325.
Email address
email
info@mngomezulu.com.
info@mngomezulu.com.
Website
That's the website.
www.mngomezulu.com. Directors, is it necessary?
Yes, it's not necessary. But
Hey, it's necessary. Why do you think it's necessary?
No, we're just going to refer to the senior associate.
Because this gentleman practices in partnerships.
It's a good.
It's not a sole practitioner.
It's a good. We just wanted to put the senior associate on record. So who's the senior associate?
Imam Womogolo.
He was a senior consulting attorney.
You're referring to the one that is just
No, senior associate.
Well, we just mentioned the directors. The directors.
Okay.
We don't have to mention the qualifications. That the directors are so and so and so and so and so and so.
the director.
Senior associate.
Director Iridineo Chia, managing director. LLB Limpopo. Katiso Mphahlele, LLB Vets. LLM Labor Law UP. Certificate in Law Dispute Resolution Stellenbosch. Senior Associate in Tokozo Mchiako.
Senior Associate to those of Chiab,
LLB Vets.
so the LLBA vets,
PDM Vets.
to the EDM, NASA vets,
Tataraki Senior Consulting Attorney Melanie Naidu.
to the senior consulting attorney Medan Naidu,
PA Vets.
to the PAS vets,
LLB Vets.
LLBS vets,
LLM Vets.
to an LLMS vets,
Advancing Diploma in Banking from Bankas Institute of South Africa.
after stipulating the banking transfer as South Africa,
Junior Consulting Attorney Faith Huntley.
I think many who was in the big country,
LLB UNISA.
to the LLBS.
It was put to you by counsel for case number 2 regarding exhibit RR. There is now the court proceedings in Mogane.
Moleledi wa molatufatso wa bobedi yena o ile a bolela ka botlhatsi ba RR e leng dilo tse di diragetseng kgolong ya Mogane.
And then so now come and go with the
That is correct.
It was put to you that accused number 2 did not appear in court on the 22nd of June 2020.
Ba ile ba re botsa gore molatufatso wa bobedi yena ga se a tswelele mo kgorong ka di 22 tša June 2020. I do recall that.
If I can ask you to turn to exhibit RR.
Ba re le go botlhatsi ba RR. Yes, I am in possession of it.
If we turn to the 4th page from the beginning.
Ba le tsebe ya bone.
Can you just place on record what's written there?
Ba re re botse gore le paging la bone go motsweng.
P04.
On top it is written P04.
A171/20 on 13/7/2020 on 13/7/2020.
No, the 4th page from the beginning. Yes, can you just put that on record?
With your agenda 29/6/2020. 29/6.
29/6/2020.
Legal aid in custody, no bail.
legal 80 kungaphakathi akanayo ibhili.
And what is your recollection? Yes. As far as the presence of the accused at court on the 22nd of June 2020 is concerned?
Lena kgopolo ya lena e reng ka go tswelela ga molatofatšwa ka di 29 tša June 2020?
Molatofatšwa o tšweletše pele ga kgoro ka yona di 29 June o išitše ke nna ka pele.
The accused appeared in front of court on the 29th of June, and I personally took him to court.
No, we talk about the 22nd of June.
22nd, yeah, 22nd, yes.
On the 22nd.
So, why the legal 27 June 2020? What happened the second week?
Right, then on the 29th of June, just the following page, 29 June 2020.
At the 29 June 2020.
Until 29 June 2020.
Just plays on record what's written there. The magistrate. Yes, 29 June 2020.
Agent 29 June 2020, legal aid in custody, no bail.
39 June 2020. So that we said legal aid.
Yes, and the following appearances on 29 June.
29 June.
Here in the page 4, the 13th of 7, 2020.
No, 29
June.
It's written page 3 at the top.
Page 3. There is no page 3 on this document. This one does not have page 3.
This was the incident.
Which is page 3, A171/20.
Page 3, number?
A171.
A171
from page 3.
20.
In which presiding on the 29th of 6, presiding officer Miss A. Rose. Miss A. Rose.
A.
Rose.
Prosecutor Mr. Lestrope, Mr. Mohapais.
No, 29 June is written page 3 of this. Yes.
Sorry.
Yes, the witness on.
Oh, there, okay.
Get on report, but we have the year.
Oh, Yama told me with your court not working.
This one is written court not working.
Accused not brought in court isolation for COVID-19. Agent to the 13th of July 2020 in absentia in custody, no bail.
July 2020.
You remember this appearance of the 29th of June 2020?
Yes, I do remember it, ma'am.
Do you remember why the accused was not before court on the 29th of June 2020?
A case here, COVID-19 Valeria police station.
Yes, I recall because there was a case of COVID-19 at Valeria police station.
Counsel for accused number 1 and 2 also referred to exhibit VV1.
VV1.
It's a report from Sibanye.
So now, American sort of kind of video.
Dental services.
VV1.
Yes, I can see it. It is in front of me.
The date is the 22nd of June 2020.
Date is 22 June 2020. That is correct.
You mentioned in cross-examination by counsel for accused number 1 and 2 that you took accused number 2 for this dental examination after the court appearance on the 22nd of June 2020.
Lile la bolela re be le motšwedi mo la ke ramolao wa molatofo bobedi gore le na le ile ka motšha ba ile mo tlhola meno. It is correct.
What
was the purpose of this examination, the dental examination?
Really, re penya molato wa 636 wa kra le gore mo senepe se ba montšhitše go sona o ba na le gold o tswile motho a rona le gold so be re tšha kwa lona sala ba le gold in a moment.
While we were still investigating the matter of 636, there was a picture which depicted a person that had a gold tooth, my lord, and we went to see if he has ever had a gold tooth before.
Can you just place these details under other details on record?
Other details.
Other details with you. Look how who shall be more.
Can you please show me where my
patient report?
Or patient report.
Operation, okay. Further details.
Further.
Yes.
Patient report have been admitted for a heart condition in 2014. Following mining accident.
If I can ask you to turn to exhibit JJ.
I do not have JJ in my copy.
There on the S3, can you just put in record what Ms. Cronier wrote there? There where there's a star.
Oh. I do not want to report any medical conditions or injuries.
Yes.
Except had a heart problem.
manje ukuthi bakwaba nesifo senhliziyo.
Thank you.
Sorry, that annotation by Ms. Konje, what date was it made?
It was on the 24th of June 2020.
24th of June. Okay.
Exhibit JJ.
2020. Exhibit J.
JJ.
JJ, yeah. That was the pro forma.
The pro forma.
Okay.
Now, if I can ask you to turn to page 2 of Exhibit BB1, the dental report.
Earlier on page 2, which has BB1, the report here, which follow ameno.
There's a clinical examination. It was put to you by counsel for accused number 1 and 2 that accused number 2 was tortured, assaulted, and chewed on the 19th of June 2020.
Ummeli kaMsolosipilo uthi uMsolosipilo wathi wahlukunyezwa washaywa wasefakwa neshubhu ngomhla ka-19 kuJune 2020.
During the oral examination, what was the finding regarding the general appraisal?
General
Mehlala-ke kwabikwa kwathini?
General appraisal is normal.
Ke konke
TM joints normal.
ama-TM joints hayi akahle.
Lymph nodes normal.
Athi ama-lymph node alungile.
Intraoral exam normal.
Bheka la ngaphakathi emlonyeni konke kulungile.
Lips and buccal mucosa normal.
Athi-ke isikhumba phakathi komlomo ney'ndebe zomlomo zikahle.
Oropharynx and tonsils normal.
Athi-ke ama-tonsil nalapho qoqoqo konke kulungile.
Palate normal.
Ke ngaphakathi emlonyeni ngaphezulu phahla lomlomo lona lungile.
Floor of mouth normal.
Athi-ke lana ngaphansi emlonyeni konke kukahle.
Tongue abangwala silo.
On tongue, they did not
Kakhulu
take anything.
bangalutho-ke ngoli
Elatela ngiri gingival and periodontium yangwala abnormal marwangwala ginginal recession aksuna wawali number 41423.
And it is written ginginal recession of 41/42/3. Yes.
so-ke ishintsho ne periodontium konke gingival recession of 4142 interdental space nakhona 112 to 112.
Megamorphosis yangwala angle classification class 1. Then your teeth chart, interdental spaces, your 11.12,21. Come on, class your 23,12. Very good category like so on the general.
On the tip chart, it is written class 1 interdental space 11 arrow 12, 21, 22 arrow 23,
12, and it seems like there are letters that were cut, my lord, as the witness cannot see them properly.
Joy, lapho ukhombisa-ke ukuhlala kwamazinyo, ukhumbula-ke isikhala esiphakathi namazinyo, kuthiwa kunesikhala phakathi kwezinyo 11 kwelesibili nesikhala esingemva ka-21 bese kuba nesikhala phakathi kwezinyo lemashumi amabili nezinyo lamashumi amathathu kwase kubekwa-ke nesikhala ngaphansi kwezinyo leshumi nambili kodwa khona okunye okungaseceleni ukugcinela kungasabonakali kahle.
So, but please, my lord, this is 4, way past our normal time of adjourning.
Still going to go on.
Can we adjourn about 1 or 2 further questions? Maybe then adjourn until
tomorrow. Okay, any objections? Adjourning at further 2, Paul?
Object.
None.
My lord, may I make a request on the I'm not intending to interject on the evidence that the state is busy with. I believe the document that the state is busy with was not admitted under Section 220.
Which document is that?
The one for medical examination of the accused.
One which? The one of the dental examination?
That's correct, my lord.
You told me that you agreed.
No, you. I just consulted.
Mr. Baloi, didn't you tell me that?
It was sent up by the defense, my lord. So he said we don't know.
On one case.
So you are objecting to its handing in?
My lord, it related to the date of the 22nd of June.
Yes, but the point
not
is,
on the contents.
Are you objecting to the admission of that?
That's correct, my lord.
You are objecting to it?
Yes, correct.
But it's been court, it's before court. You can address me tomorrow.
That's correct, my lord. I'll do so.
And who handed in this document?
It's the defense, my lord.
Yeah, as I recall, Mr. Mngomezulu himself. Okay. Can you number that order, that court order? Give it a citation. I don't know exhibit what. Are you with me?
Yes, it will be exhibit W.
Exhibit?
WW.
Exhibit WW. That is the apparent confidential report of the sergeant. Are you available tomorrow, sir?
Yeah.
Okay. 10 o'clock tomorrow.
Okay guys, the court session has been postponed for tomorrow at 10. Apparently Baloi has introduced some new evidence as well, the dental side of things. I'm not sure why he's introducing some new things now. Yeah, it's quite interesting, but we'll see how it goes along the way. We'll see how it's going to go, but it's turning upside down now because there's a lot of things that have been said. Someone was actually saying Shololo was actually going offline. That's why they had to stop here, something like that. But I thought maybe she was trying to find an amicable solution on certain matters. But let's just see how it's going to go tomorrow. But thanks for the WhatsApp voice note, because I think I had one that I did not play. Let me just play this one voice note and then we close the session.
Nokunye osekungiphatha kabi manje uMogane usethi Mngomezulu uthole extract yenongoma case leyo case ephethwe uMngomezulu angazi noma bahlobene naye ngendlela angayiboni kahle ngathi banenhloso ethile manje noMngomezulu. Mogane manje useveza lesithembu sokuthi manje uMngomezulu kube ngathi akwenzayo sekwenza okwrong ngokuthola le information. Kanti umthetho wame-defense ukuthola information elekelela i-case. Usefuna manje like uyamthreatenisha manje uMngomezulu ukuthi le information uyithola phi ngoba methola umphathi wecala lapha uMngomezulu. Sesazi manje ukuthi kunoMngomezulu ophethe icala laleya case yakanongoma. Bengasho ngani kanti ekuqaleni ukuthi leya case iphethe ubani. Usekhala ngama-extract befana angayitholi i-extract ezofakazisa ukuthi le nto ayishoyo icase yakanongoma ubani wagwetshwa waboshwa kuyona. Le waboshwa kuyona ubuthelisi loyo wagwetshwa 15 years ethi involve lokhu zonke. Le document ilindiwe phela ilethe ukuthi accuse bani uNtanzi. Indoda yayisiqala manje yabhibhidla yathi hayi uyithola ngendlela errong. Usho ufuna manje inkantolo ichithe ubufakazi bale document futhi elethe uMngomezulu ukuthi uyithola ngoba uyamuntu lapho nolwazi lwayo uyamuntu uMngomezulu ubumseshi. Yes, so far siyilanda la kule case yanitshela.
Chico, I want you to hear what Siyabonga Mia had to say to us yesterday for your benefit and for the benefit of any of the listeners who are hearing us now who may not have heard the conversation yesterday.
They know with the person who shot Senzo is Longwe Twala.
Why would they protect him?
Senzo died trying to protect his girlfriend. I went to the DPP's Chauge's office and he said to me the people who were inside the house were lying. You understand? But why they didn't sign those warrants, I don't know.
Why would they protect him, do you think, Siyabonga? Why would they protect the people you are saying are guilty for killing Senzo Meyiwa?
Some people born with a silver spoon in their mouth. It's so unfortunate for Senzo Wuti. He didn't born with a silver spoon in his mouth. Everything that he had, he fought for it.
What's your response to those allegations? Siyabonga Mia basically making the point that your son is the son of a very powerful man, words Longwe himself has used to describe you. What do you make of that, of those accusations?
I think it's important for someone to understand that I'm not powerful. And to be honest with you, why would Senzo's childhood friends to Melo Madalem Togozi to defend my son? Common sense.
Look, we hold a view, and a very strong view, that Senzo was killed. And those people in the house know who killed Senzo. We're more than convinced. Personally, I'm more than convinced Kelly knows. I'm more than convinced that she knows something. And there must be a way she must be held accountable. But it must be done in an orderly manner so that its outcome is not questionable.